Justice Chandrachud in paragraph 9 and 15, but I've given the references to your lordship there. In paragraph 9, the judgment was noted with regard to section 55 of the Constitution 42nd Amendment Act, amending Article 368, and in paragraph 15, it was noted that Minerva Mills struck down section 4 of the Constitution 42nd Amendment Act. The challenge with regard to 31C was considered and dealt with in paragraph 52 to 54. As your lordship says, there are only two really relevant paragraphs. That leaves for consideration the challenge to the constitutional validity of the unamended Article 31C. As we have stated at the beginning of the judgment, Article 31C was introduced by the Constitution 25th Amendment Act 71. Initially, it sought to give protection to those laws only, which gave effect to the policy of the state towards securing the principles specified in clauses B and C of Article 39 of the Constitution. No such law could be deemed to be void on the ground that it is inconsistent with or takes away or abridges the rights conferred by Article 14, 19, and 31, the concluding portion of the unamended article, which gave conclusiveness to certain declarations, was struck down in Kesavanand Bharati. 54. So, my lord, the one plank of the reasoning was Kesavanand Bharati. Now, my lord, the second. Apart from this, so, my lord, in addition to that, if we are right in upholding the validity of Article 31A on its own merits, it must follow logically that the unamended Article 31C is also valid. So this was on parity of reasoning between 31A and 31C. The unamended portion of 31C is not like an uncharted sea. It gives protection to a defined and limited category of laws which are passed for giving effect to the policy of the state towards securing the principles specified in clause B and C of Article 39. These clauses of Article 39 contain directive principles which are vital to the well-being of the country and the welfare of its people. Whatever we have said in respect of the defined category of laws envisaged by Article 31A must hold good, perhaps with greater force, in respect of laws passed for the purpose of giving effect to clause B and C of Article 39. It is impossible to conceive that any law passed for such purpose can at all violate Article 14 and Article 19. Lord, it's sentiment expressed, my Lord, the Chief Justice yesterday as well. Article 31 is now out of harm's way. In fact, far from damaging the basic structure of the Constitution, laws passed truly and bona fide for giving effect to the directive principles contained in clauses B and C of 39 will fortify the structure. We do hope that Parliament will utilize to the maximum its potential to pass laws genuinely and truly related to the principles contained in clause B and C of Article 39. The challenge made to the validity of the first part of unamended 31C therefore fails. Or just by way of summary. So, there are two grounds. One is Kesavananda Bharati has already upheld it. But the second independent ground is that if we uphold 31A, agrarian reform, and other such similar laws, then surely on parity of reasoning, we must also uphold 31C. And Lord, the very important observation, which I'll come to later on, Lord, where the learned Chief Justice says that how could a challenge based on 14 and 19 succeed against a law which is truly towards the purpose of 39B and C? Not something which my Lord Justice Dhulia sort of echoed in the example and the discussion on 39B as well. If it's truly towards alleviating inequality, what is your possible challenge under 14 and
39 with 38?
38. Sorry.
And in this, the reasoning is given that it gives protection to a defined and limited category of laws which are passed for giving effect to the policy of the state towards securing the principles specified in clause B and C of Article 39. So because it is specific
and limited,
it is not the entire directive principle. Therefore, it is valid.
Your Lordship is perfectly correct.
So it is not just because 31A and 31B have been upheld, therefore we are doing it.
No, Lord, I would agree.
The reason is this.
No, your Lordship is correct, but perhaps
B and C, to that extent, fine. If you take the entire directive principles, no.
But for a specified purpose, namely
specified purpose is 39A, B and C.
B and C, Lord, it passes muster. So, Lord, independent reasoning. But that's what I wanted to impress upon your Lordship. Not only Kesavananda Bharati, but independent reasoning. But some may say, so far.
Look at the language, just the sentence after that.
Please, my Lord.
It gives protection, as my brother just now read out,
My lord.
protection to a defined and limited category of laws which are passed to give effect to the policy of the state towards securing the principles specified in Clause B and Clause C of Article 39.
My lord.
And these clauses of Article 39 contains directive principles which are vital to the well-being of the country and the welfare of the people. Just look at the brilliance of the articulation.
There is no
Really
doubt
lovely,
about that.
unmatchable, actually.
Or I would say one thing, my lord, that, or I said it the other day also, my lord. This was an age of masterful writing, my lord. And my lord, in particular, my lord, some of these judgments. My lord. Or the bar was set very, very high for all of your lordships, my lord. My lord, I've attempted an analysis, my lord, in Roman 5 and 6. My lord, from the concluding part of paragraph 53, it is clear that Article 31C was inter alia upheld on the basis of the ratio of the majority judgments in Keshav Nanda Bharati. However, the fact that this was not the only basis is also evident from paragraph 54, which by its lucid reasoning provides inter alia that Article 31C gives protection to a defined and limited category of laws. To both of your lordships' point, the lucidity as well as the limited nature of 39C. Pass for giving effect to the policy of state towards securing the principles specified in clause B and C of Article 39. That Article 39 was vital to the well-being and to the welfare of its people, and whatever was said earlier in the judgment with respect to defined category of laws envisaged by Article 31A must hold good perhaps with greater force in respect of laws passed for the purpose of giving effect to B and C of Article 39. The learned, I should say the Chief Justice, I'm sorry, Mal, went on to state that it was impossible to conceive that any law passed for such purpose could violate 14 and 19. Lord, in paragraph 55, the judgment also clarified. Lord, this is a very interesting clarification, actually. Lord, and Lord, it actually occurred to me, Lord, it has great bearing on the Colio point, but Lord, I'll leave that for now. Lord, in paragraph 55, the judgment also clarified that the individual examination of laws, Lord, I've not extracted it, perhaps I can read to your lordship. The individual examination of laws inserted into the 9th schedule on or after 1973, which provided for earlier in the judgment against the basic structure of the Constitution, would become ocious if such laws fell within the scope of 31A or the unamended Article 31C. And accordingly, it would become unnecessary to determine whether they receive the protection of Article 31B read with the 9th schedule. So, Lord, what the learned judge said was this, Lord, that you don't need to check whether the law which is inserted into the 9th schedule is violative of 14 and 19 if it is already covered by Article 31A and by Article 31C. So, my Lord, some powerful reasoning, my Lord, with regard to 31C. Now, my Lord, I've only mentioned overleaf, my Lord, just as a matter of fact that there was a dissent in that judgment. My Lord, Justice Bhagwati, after delivering a dissenting judgment and Lord, Justice Bhagwati, delivering a dissenting judgment and reiterated that he had already given his reasons for subscribing to the order delivered earlier in his dissenting judgment in Minerva Mills, and that the same should be treated as forming a part of the present judgment. He expressly identified various portions of Minerva Mills' judgment as the reasons for making the order of 9th May 80 in the present case. Now, Lord, since it's a dissent, Lord, and in the interest of economy of time, Lord, we need not go into it, Lord. So, Lord, it doesn't have any legal effect. Now, my Lord, my comment on Vaman Rao is as follows, my Lord, and my Lord, this may be taken as my submission on it, my Lord. Comment on Vaman Rao in relation to whether it can be regarded as having decided the question of revival of unamended Article 31C. Vaman Rao was concerned with the question of validity of the unamended Article 31C. In Vaman Rao, the Act of 1961 was being challenged, inter alia on the basis described in the judgment above. As is evident from what is stated above, the challenge in all proceedings before the Bombay High Court and the Supreme Court were in respect of matters prior to the 42nd Amendment Act taking effect on 3rd January 1977. So, my lord, in terms of temporal analysis, it was all before this amendment took effect. It is submitted that paragraph 3 of the order of the court dated 9th May 80, which held Article 31C unamended, is valid to the extent to which its constitutionality was upheld in case of Nanda Bharati and does not damage any of the basic or essential features of the Constitution or its basic structure. I paraphrase the order. Must necessarily be understood in respect to the challenge and grievances which were raised in the proceedings before the Supreme Court. But this is how I've tried to deal with it now, Malam. But it is well settled that judgments must be read as judgments in the facts of the case and not in abstract. The principle applies to judgments on constitutional law as well. It is further submitted that the judgment in Vaman Rao must be understood in the context of the constitutional challenge that was made there, i.e., a challenge that the unamended Article 31C was in breach of the basic and essential features of the Constitution and stroke or the basic structure. This was the only challenge which was repelled, and the declaration of validity of unamended Article 31C in the judgment must be understood in this context. Not overly. It is submitted that a Constitution Amendment Act or an article of the Constitution may be held to be valid against a particular challenge by repelling that challenge, but unconstitutional on another challenge by accepting the grounds of the other challenge. The mere fact that the constitutional provision is held to be valid by repelling a particular challenge does not confer upon it a constitutional validity in perpetuity, which safeguards it against future challenges of a different nature.
You have to elaborate on this. What are you trying to say in this?
Madam.
6.
Yes, madam.
Submitted that
But may I read it again, madam? But this is my proposition to your lordships, madam. But I'll try to elaborate it a little further, my lord. May I just go through the note and then deal with it extempore, my lord, with your lordship? I've tried to actually deal with it further because this is the nub of my argument to your lordships. Illustratively, to my Lord Justice Dhulia's point, this is how I've tried to explain it because I understand, my lord, that this requires some elaboration. It is entirely possible that a constitutional provision may be held valid against a challenge under Article 19 by repelling that challenge and yet subsequently be held unconstitutional against a challenge under Article 14 or 21. It is an admitted position and evident from the record that the Honorable Supreme Court in Vaman Rao did not consider the validity of unamended Article 31C on account of the judgment in Minerva Mills holding Section 4 of the Constitutional Amendment Act unconstitutional, on the ground that it damaged the basic structure of the Constitution. So, Lord, this issue of revival was not present to the judges in Vaman Rao at all. It is also evident from the record that Chief Justice Chandrachud for the majority repelled the challenge and upheld the validity of unamended Article 31C solely on the grounds stated in paragraph 53 and 54. As such, now this is my conclusion, Vaman Rao has no precedential value whatsoever with regard to the present issue, and in fact, as from what is stated above, demonstrates that the challenge was on an entirely different basis. So, my lord, this is my attempt to grapple with the problem which your lordships presented to me yesterday. My lord, just a few comments on this, my lord. So, my lord, stepping away from Vaman Rao, etc., just as a general principle of constitutional law, my lord, a constitutional provision may be challenged on various grounds. Or just illustratively, I've given your lordship an example of 19, 14, and 21. Lord, conceptually, My lord, I don't think, my lord, I could be said to be wrong, my lord, to conclude that one might succeed, another might fail. Lord, when one fails, or let us say an Article 19 challenge, Lord, the statement of validity by repelling that challenge is just that. It is to say that it is valid against that challenge, but not to say that it remains valid against other potential future challenges. So, my lord, I, for one, my lord, see little difficulty in accepting the conceptual position that a article which survives a 19 challenge may fall to a 14 challenge. Lord, there is another more elaborate aspect to this also. Lord, if we accept what is undoubtedly true, my lord, that our constitution is a living document and that our constitutional values change with time, Lord, it is entirely possible that a challenge made under a particular article of the Constitution, say 14, might fail in 1976, but may succeed in 2024. I'm not the leading example, of course.
Then we have to reconsider that judgment.
Your Lordship may have to, and therefore I come to that point that I am free of that difficulty because I'm before 9 of your Lordships, and those were 5. Yes, my Lord, it is entirely possible. It may require a comment on that judgment.
But we are again subservient to a decision of 13.
Yes.
I have something to say. Yes, no, your Lordship is right. So that Keshav Nanda problem, my Lord, is a problem. My Lord,
You know, if both Minerva and Vamanrao particularly was just based on a judgment of 5, of course we could have reconsidered it. But today Vamanrao admittedly says that the validity of 31C, the unamended 31C, has been upheld in Keshwanand.
no, my Lord,
That stares us in the face. So the only point then which we have to consider is this, that since Minerva struck down the entirety of Section 4 of the 42nd Amendment, which included 39B and C as well.
but that is a later part of my argument.
Yes.
Yes.
Does that part relating to 39B and C get revived? That's the only point.
Your Lordship is right. Lordship.
Because reconsidering now Vamanrao, that will not really rise because Vamanrao in turn follows. Though of course they've given additional reasons, but it follows Keshwanand. And irrespective of the additional reasons in Vamanrao, we are bound by Keshwanand.
Lord, I accept what your Lordship says, and I didn't think your Lordship would say anything to the contrary. Lord, just by way of an interesting aside, my Lord, one of the judgments, Lord, it has a fascinating analysis of the doctrine of precedent. This is not quite the precedential point, but it speaks about how the Normans always regard the older law as the better law. If I'm not wrong, my Lord, once again, is Justice Chandrachud's judgment.
But Mr. Anjashna, you are right that a constitutional provision which has been upheld against a challenge on one particular constitutional ground, the validity of that constitutional provision can be considered by the Supreme Court itself.
Of course.
On other grounds, Ali and Day. High courts can't do it.
Exactly.
The Supreme Court has upheld the constitutional validity under 19. High courts cannot say that, well, 14 was not considered for another reason as well, that 19 and 14 are now no longer treated as silos. They all amalgamate with each other. And after post Cooper and
Maneka Gandhi, they all bleed into each other.
But Supreme Court can certainly say that, well, in that case, the challenge was on the ground of legislative competence. We look at the fundamental rights challenge here. Second, a provision which is constitutional and that applies to a legislative provision, on the date when it was enacted may cease to become constitutional later on, which was the principle laid down in Motor General Traders by Justice Venkatamaya as the Lordship then was, and followed in Malpe. Right, and that's how Malpe said that, look, this provision was valid when it was enacted in the Bombay Rents Act in 1947, but no longer valid now. Those two issues do arise. But now, we really, the narrow issue which we have to consider is this. What is the effect of the declaration of Section 4 of the 42nd Amendment as unconstitutional? Will that, in that sense, affect the operation of the unamended Article 31C? Your point really is this, that unamended Article 31C was confined to 39B and C. That was subsumed in the expansion. The entirety of the expansion is struck down. So where is the question of revival? To which possibly the answer would be that, look, the reasoning in Minerva in that paragraph, which you come to
Yes.
in a later part of your note, I was actually preempting you because I was reading ahead of you. That discussion in Minerva is not in relation to the validity of 31C in relation to Article 39B and C. That discussion in Minerva is actually about this wide expanse now which has arisen, that all provisions, if a law is passed in provision in pursuance of any of the directive principles, it's immune from 14 and 19 challenge. This they said was not this they said was unconstitutional. But they were not for a moment. They couldn't have doubted. Keshwan and Bharti. And so were they purporting to doubt Keshwan and Bharti? They had to issue that declaration for the reason that there was no severability arising there, because it was one omnibus provision, all or any of the principles in the directive principles. I mean, you take that too honestly in a matter like this. There are two.
It's arguable either way.
Open.
Of course, it's always arguable either way.
But it's arguable either way. But then, do we strike down? Do we say that, you know, when this is the constitutional history, that do we say that, look, now 31C in its entirety is
But let me
effaced?
show your lordship there the constitutional principles with regard to the declaration of unconstitutionality and on effect on substitution. That's a separate.
Finished your Vaman Rao part.
I finished with Vaman Rao, and I think your lordship.
Minerva, because then, then we can go into the heart of the
yes,
matter.
Lord,
And, you know, I don't think
straight away. Now, my Minerva also I've tried a lot to do a little bit of extraction for your lordship's convenience.
Yeah, actually, that's good because, you know, that's really the relevant part of Minerva.
So, my lord, this is page 99 onwards.
But the fact remains that in Vaman Rao, whatever has been stated is subsequent to the judgment in Minerva Mills.
Yeah.
That is true.
Challenge is to a stage anterior to Minerva Mills. The bench is conscious of what they have stated in.
No, my lady is right. That is a difficulty in my way, but I'm trying to deal with it. Yes.
Stated.
Yes. That is actually the problem for me, but which I'm trying to grapple with and deal with. But would your lordship like to see Minerva for a second?
Yes, just see para 58 at internal page 10 of your note.
Yes, para 58 straight away. Lord, but can I come back to the rest a little later? Lord, straight at 58. I want to deal with that concession point also to my Lord Justice Rishikesh Roy's point.
Para 24.
Very well, Lord, whatever your
But
lordship.
you know, the thing is that concession now, I think
Very well.
it's pretty clear.
Very well.
But they say Mr. Palkhiwala conceded that the unamended Article 31C is valid.
He could not have done so otherwise.
They say, and rightly so, because of, then they refer to Keshwan.
Lord, I am content with that. Lord. Please come straight to paragraph 8.
58.
Then. Paragraph 8. Lord, it is in this light that the validity of amended Article 31C has to be examined.
Just
But
one second. Just
please,
one second. Page 10, internal page.
Page 101, my Lord, I find.
Yeah,
And para 801.
PDF 10, page 101.
58 of Minerva Mills.
Yes, my Lord.
101. 101.
Yeah.
So extracted. सबको मिल गया ना?
Yeah, extract.
And this problem of pagination is it's a perennial problem. I've been trying to solve it myself, but there's something called Bates numbering, my Lord, which actually links it with the way that it is numbered in hand. I've not yet been able to solve it entirely, but I've been.
I tell you now that I don't want to break the flow of your argument. This is a perpetual problem. You know, now we have electronic files in the Supreme Court. What we find is that the page with the lawyer's side of the electronic file is not the same as our page.
Yes, my Lord.
So I said there is a technological problem.
No, but
Everything in technology can be resolved. So we've resolved it. The only thing it requires a little discipline on the part of the lawyer.
Arrangement, it's how you arrange it.
What happens is,
Yeah.
the moment, say, an office report comes in, our digital files are divided into 3 segments. Volume 1 is the original paper book.
Well,
Volume 2 is what we call the additional paper book, which will contain the rejoinders, counters, rejoinders, interim application. Volume 3 is the record of proceeding.
well,
Now, when a new pleading is filed in Volume 2, the pagination of Volume 2 will change. When a new office report comes, and pagination of Volume 3 will change. We email it to the lawyers automatically. They don't have to download it. It's in the lawyer's inbox. The trouble is, advocates on record, when they brief seniors, don't take the they don't take the trouble of looking at the latest uploading. They will have something 5 or 6 days earlier. Now what last night I was sitting till late with my staff. I said, how do we find this solution? So now we are coming out with a solution called versioning. So the lawyer's copy will have and our copy will have the date, the time and the precise 14 hours, 23 minutes, 32 seconds on such and such a date. So we have to make sure that we are on the same version. As the bar.
Right.
So it has a solution. It just requires a little bit of more discipline on the part of the bar as well to lift the latest versioning.
Right.
Okay.
I dare say, my lord, in the
I share it in the hope that, this travels beyond the voices in this court and people all realize that this has been done now by the Supreme Court. So, the latest version.
Lord, paragraph 8. Lord. What paragraph 58 deals with the question of validity of amended Article 31C. In this light, it is in this light that the validity of amended Article 31. Please, my lord, please.
The sentence starts, para 58, it is in this light.
Yes, my lord.
Can you read para 57
Of course, my lord.
in volume 5,
Yes, of course.
page 2079?
Certainly, my lord.
That may give us some
Certainly.
more clarity.
Thanks again.
That's always a peril of this.
Contacts with, it is in this light that the validity of the amended Article 31C has to be examined.
But allow me to read 57.
Please.
And I'm obliged to.
Please.
Lord, would your lordship mind if I read 56 only?
Okay.
56 onwards. This, because it's beautifully written again. The significance of the perception that parts 3 and 4 together.
Just 1 second.
Yes, bro. That's at page 2079. 2079. I am grateful to your lordship, and I think it will be much better if I read both of this to your lordship first.
Yes.
Yes.
May I? My lord, the significance of the perception that parts 3 and 4 together constitute the core of commitment to social revolution, and they keep together are the conscience of the Constitution, is to be traced to a deep understanding of the scheme of the Indian Constitution. Granville Austin's observation brings out the true position that parts 3 and 4 are like two wheels of the chariot, my lord the Chief Justice put to me the other day. One no less important than the other. You snap one and the other will lose efficacy. They are like a twin formula for achieving social revolution, which is the ideal which the visionary founders of the Constitution set before themselves. In other words, the Indian Constitution is founded on the bedrock of the balance between part Roman 3 and 4. To give absolute primacy to one over the other is to disturb the harmony of the Constitution. The harmony and balance between the fundamental rights and directive principles is an essential feature of the basic structure of the Constitution. Then 57. This is not mere semantics. The edifice of our Constitution is built upon the concepts crystallized in the preamble. We resolved to constitute ourselves into a socialist state which carried with it the obligation to secure to our people justice, social, economic, and political. We therefore put Roman Part 4 into our Constitution, containing directive principles of state policy which specify the socialist goal to be achieved. We promised to our people a democratic polity which carries with it the obligation of securing to the people liberty of thought, expression, belief, faith, and worship, equality of status, and of opportunity and assurance that the dignity of the individual will at all costs be preserved. We therefore put Part 3 in our Constitution, conferring those rights on the people. Those rights are not an end in themselves, but a means to an end. The end is specified in Part 4. Therefore, the rights conferred by Part 3 are subject to reasonable restrictions, and the Constitution provides that enforcement of some of them may, in stated uncommon circumstances, be suspended. But just as the rights conferred by Part 3 would be without a radar and a compass if they were not geared to an ideal, in the same manner, the attainment of the ideal set out in Part 4 would become a pretense for tyranny if the price to be paid for achieving the ideal is human freedoms. One of the fates of our founding fathers was the purity of means. Indeed, under our laws, even a dacoit who has committed a murder cannot be put to death in the exercise of the right of self-defense after he has made good his escape. So great is the insistence of civilized laws on the purity of means. The goals set out in Part 4 have therefore to be achieved without the abrogation of the means provided for in Part 3. It is in this sense that Part 3 and 4 together constitute the core of our Constitution and combine to form its conscience. Anything that destroys the balance between the two parts will ipso facto destroy an essential element of the basic structure of the Constitution. I'm deeply obliged to you, Lordship. Now
It is in
58.
this light.
No, yeah, I'm deeply obliged to you, Lordship. Now it's much better now, my Lord, to read 58. Because it is in this light that the validity of the amended Article 31C has to be examined. Article 13(2) says that the state shall not make any law which takes away or abridges the rights conferred by Part 3, and any law made in contravention of that clause shall to the extent of the contravention be void. Article 31C begins with a non-obstant clause by putting Article 13 out of harm's way. It provides for a certain consequence notwithstanding anything contained in Article 13. It then denudes Article 14 and 19 of their functional utility by providing that the rights conferred by these articles will be no barrier against passing laws for giving effect to the principles laid down in Part 4. On any reasonable interpretation, there can be no doubt that by the amendment introduced by Section 4 of the 42nd Amendment, Article 14 and 19 stand abrogated at least in regard to the category of laws described in Article 31C.
You will have to elaborate this.
I will. I'm obliged to. The startling consequence which the amendment has produced is that even if a law is in total defiance of the mandate of Article 13, read with Article 14 and 19, its validity will not be open to question so long as its object is to secure a directive principle of state policy. We are disposed to accept the submission of the learned Solicitor General, considering the two charts of the case submitted by him, that it is possible to conceive of laws which will not attract Article 31C, since they may not bear direct and reasonable nexus with the provisions of Part 4. But that, in our opinion, is beside the point. A large majority of laws, the bulk of them, can at any rate be easily justified as having been passed for the purpose of giving effect to the policy of the state towards securing some principle or the other laid down in Part 4. In respect of all such laws, which cover an extensive gamut of the relevant legislative activity, the protection of 14 and 19 will stand wholly withdrawn. It is then no answer to say, while determining whether the basic structure of the Constitution is altered, that at least some laws will fall outside the scope of Article 31.
Back to para 54 of Vaman Rao and
My
try
lord.
to reconcile.
Before you go to Vaman Rao,
Yes, Lord.
can I just highlight three things in this
Please,
particular para?
Please.
Para 58, if you go to 2080,
Yes, Lord.
okay, at the
Yes.
last line in, on 2079,
Yes, Lord.
it then denudes Article 14 and 19 of their functional utility by providing that the rights conferred by these articles will be no barrier against passing laws for giving effect to the principles laid down in Article in Part 4.
My lord.
So there are three observations in this para which are very crucial. So will be no barrier against passing laws for giving effect to the principles laid down in Part 4.
Yes, Lord.
So now they are saying that you are giving an immunity against a 14 and 19 challenge on the ground that the law is giving effect to any of the principles in Part 4. Second, now if you could just travel a little down, the startling consequence
Yes, Lord. I have
which
it.
the amendment has produced is that even if a law is in total defiance of the mandate of 13 read with 14 and 19, now it follows. Its validity will not be open to question so long as its object is to secure a directive principle of state policy. That's the second.
My lord.
They're looking at now the width of the amendment
Correct.
provision, that
Correct.
it gives effect to any of the directive principles. Third, a large majority of laws, the bulk of them can at any rate be easily justified as having been passed for the purpose of giving effect to the policy of the state towards securing some principle of the other laid down in Part 4. Three very critical observations in this paragraph. So what they find as objectionable is that there is a complete immunity to an Article 14 and 19 challenge if the law has been enacted in pursuit of any of the directive principles. Earlier, before the amendment, it was confined to specific directive principles 39B and C. Now they say what is objectionable is that canvas of immunity is extended so long as it is in furtherance of any of the directive principles. These three observations in para 58 are very crucial. Now, if you go down and travel to para 59 and then 60 for a moment.
Yes.
60 is very important.
May I read?
Very
my lord?
important, because it deals with
60
Article 30.
Because 60 dwells on what is referred to, in those three sentences.
Yes.
Any one directive, some directive principle or the other. Now just see 60 for a moment.
May I read 60 for your lord?
Yes.
Lord, and I return to your lordship's point immediately after.
We
Or
only
it was
wanted to
repeatedly,
see.
Para to 54 of
I-
Vaman Rao.
actually, my lord, what your lordship has said, I believe, has in one sense answered my Lord Justice Pardiwala's point. I believe my Lord Justice Pardiwala's point was, in 54, it was the specificity, the point which was made also by Justice Dhulia, of 39B and C, which allowed 31C to stand.
Right. So what Vaman Rao then says, we'll go to Vaman Rao in a moment, is that so long as that the ambit of Article 31C
Is narrow.
is narrow and tailored to Article 39B and C, it passes muster. Though Article 14 and 19 per se are part of the basic structure of the Constitution. Right?
Perfect.
What was objectionable in what was found to be objectionable in the 42nd Amendment in Minerva was that as opposed to a narrowly tailored immunity confined to laws in furtherance of 39B and C, you are expanding it to the entirety of the chapter on directive principles, namely part 4. Now see, para 60 will make that even clear.
Not-
60 makes it very, but that's why I highlighted those three.
I'm obliged, deeply obliged.
In para 58, where they refer to some article or the other, the entirety of part 4.
I'm deeply obliged.
Not just the para 60.
But can I say one more thing before I go to 60? Lordship permits me just a word. But all the cases, my lord, treat 31A, B, and C as one suite of provision.
Absolutely, one sweet.
Or agrarian reform was the real driving purpose of 31A and B, and then came C. So it was always conceived as a very narrow balancing act that was done in favor of directive principles against fundamental rights. To your, my Lord Justice, to both points actually. Lord,
Let's see para
yes,
60.
now para 60. my lord. It was repeatedly impressed upon us, especially by the Attorney General, that Article 38 of the Constitution is the kingpin of directive principles, and no law passed in order to give effect to the principle contained therein can ever damage or destroy the basic structure of the Constitution, a point made by Justice Dhulia
Yes.
this morning. That article provides that the state shall strive to promote the welfare of the people by securing and protecting as effectively as it may be a social order in which justice, social, economic, and political shall inform all the institutions of national life. We are unable to agree that all the directive principles of state policy contained in Part 4 eventually verge upon Article 38. Article 38 undoubtedly contains a broad guideline, but the other directive principles are not mere illustrations of the principle contained in Article 38. Secondly, if it be true that no law passed for the purpose of giving effect to the directive principle contained in 38 can damage or destroy the basic structure of the Constitution, what was the necessity, and more so the justification, for providing by a constitutional amendment that no law which is passed for giving effect to the policy of the state towards securing any principle laid down? Yes, Lord. Perfect sense, Lord. Your Lordship is.
So really, Mr. Andarjana, what the court is finding objectionable in Minerva is this expansion beyond 39B and C. So neither Minerva, and now we'll go to Vamanrao para 54 to deal with Brother Pardiwala's point. So what is objectionable even in Minerva? Minerva is not reconsidering, assuming Keshwanand was 5 judges and not 13. I'm just theoretically saying that. then Minerva could have possibly reconsidered the validity of 31C all over again. They couldn't have done that in Minerva, but that apart, what Minerva is finding objectionable is not original Article 31C in its unamended form, but the amended provision which expands the canvas of 31C to cover all the directive principles of state policy.
But with respect, Your Lordship has perfectly articulated.
Now, if you come back to para 54 of Vaman Rao,
And but when we see that, Your Lordship will see that there's perfect symmetry
there is
between
symmetry
Minerva,
between Vaman
Minerva
Rao
and Vaman Rao. There is no asymmetry in the
there's
two at all.
perfect symmetry between the two.
So, my Lord, if we go back, if Your Lordship
I'll
doesn't,
go back to 54.
my note,
Brother Patil,
my note, for
interrupted
my
him,
Lord
so
Justice
we
Padiwala's
must go
point.
back
That's
to
all
that.
right. No.
But in fact, my Lord, that was the very point expressed from the Vaman Rao point of view by Justice
You
Padiwala.
have quoted 54, right?
I have. My Lord, it's at page 96. Roman 4.
Otherwise, may I say something?
Please, my Lord.
Because if you see the other directive principles, it speaks of village industries, cottage
Exactly.
industries, animal husbandry, living, what is that, wages,
Living wage.
protection of monuments, then protection of environment. All those laws will get immunity then.
But to my
That is
lady.
why it was struck down.
But to my lady's point, Lord, that is actually once again another aspect of this. The balance was lost. If you say that everything within part 4 will take primacy, what about the earlier part which says that the constitutional tension is a part of the basic
The
structure
balance is preserved by 31C in its unamended form.
in an unamended form?
Now, once we accept that as the prevailing, the prevailing doctrine post Keshanand and even post Minerva and Vaman Rao, we'll go to para 54 in a moment. Then the only point which we have to dwell on is what happens about that slightly problematic area. It's not a clear area of the entirety of Section 4 having been struck down.
but
That
this
is
only-
a problematic area, but then
This only clears the way for that argument.
do we then say that, look, it is a problematic area? Obviously, otherwise, we would not be laboring this point and, so many three referral orders. Then do we take a very strictly formalistic view of the law by saying that the moment Section 4 was struck down, the entirety of 31C is struck down? That would be a very formalistic reading of the Constitution. I mean, we are a constitutional court. I mean, we have to pay due deference to our peers and predecessors.
Understood.
Who came in and said, look, 31C in its unamended form is valid in accordance with the social ethos. Then we are only left with this point. What is the effect of a substituted provision having been...
Lord, Your Lordship is
down?
perfectly correct. Lord, all of this
And
was
we
an...
must also bear in mind, this is not really an absolute substitution. You were right when you said it can be by way of an addition, substitution, repeal. This was really a substitution coupled with an addition. But it was not a total substitution. They just changed those three words, Article 39 B and C, and said all or any
Or
principle.
any of the principles.
But I will try to deal with those issues also. And
Just read para 54 and then I think
we can go straight to that point.
you go to the last part, which
Yes.
is the heart of your submission.
Straight to that point. Lord.
And what is the effect of the declaration of Section 4 as unconstitutional? Does that revive Article 31C?
Yes, very well.
And perhaps the simple answer would be that, look, once 31C in its amended form is declared to be null and void,
Well,
subject to your caveat that it's not obliterated from the statute book, the Constitution, it's still retained, but it's always then italicized. It's in that sense from the date of its enactment, unless it is made prospective, from the date of its enactment or adoption, the amendment to 31C is rendered non-est. If it is rendered non-est from the date of its adoption in 1976, then the prevailing position which operated up to the date of the adoption of the Constitutional Amendment is not obliterated, unless there was intrinsic evidence that Parliament intended to obliterate by the Constitutional Amendment the earlier position. In some cases, for instance, there may be a clear intent of Parliament that, look, we want to obliterate a constitutional provision prior to the date and completely substitute a new provision. That is not the intent of Parliament. Parliament wanted to extend the scope of the immunity, actually.
But I will address your lordship on that as well. But I have some thinking on that, but I will address your lordship. But your
So
lordship,
just show us para 54 and then you can go to that last part. now.
Perfect.
Then we'll call upon the other side.
yes. So, my lord, if your lordship will come straight away, my lord, to paragraph 54. But may I read it for you? Lord?
Should we quickly, then
54?
54, I think you've read, Jamshi, you wanted to read? 54 you have read. Now go to the last point.
Straight away.
That will take you just the conceptualization.
Yes.
You want the conceptualization.
Lord,
Now we've
may
seen
I-
the law, the judgments and everything.
Just say, but just to complete this, just 2 words, my lord. My lord, the succeeding judgments, Lord Bhimji Sen's judgment, Lord
Bhim Singh Ji is that.
Bhim Singh Ji's judgment, sorry.
By the way, Mr.
Sir-
Bhim Singh Ji used to come here. He was unfortunately passed away I think a couple of years ago in COVID or post-COVID. Used to
During
be up
COVID,
here.
I
Yeah.
think there was a reference made.
Singh Ji had filed a public interest litigation, which I allowed, where he said that the army porters who serve in the border areas, they have no security of tenure. They have nothing. If a porter falls, if any of you have gone to Ladakh and you see those porters just near the border areas, they are with their mules, and it's very treacherous. And he said, there's nothing. The man just falls, he's gone. There's nothing for his family. So we allowed his petition, asked the army to come out with a social welfare security net for, thanks to Mr. Bhim Singh. A very, puny sort of a person, used to come and make his point. But he headed the Panthers party.
Yes.
And the first judgment saying that compensation can be granted for a violation of fundamental rights is in Bhim Singh's. It was preceded by Rudul Saha was preceded by Bhim Singh Ji, where he was detained in Jammu and Kashmir in those days, and our court awarded some compensation, I think, to him. Then came Rudul Saha and D.K. Basu and everything. Yes,
My lord, just to complete that, my lord, the 3 judgments, my lord, Bhim Singh Ji, my lord Sanjeev Kok, and Basanti's case, my lord, they did not deal with a direct challenge to 31C. They all proceeded on the basis that it is valid today. And they were, my lord, in a challenge to the Urban Land Ceiling Act, a challenge to a part nationalization of Coal Mines Act, and a challenge to a different part of MADA as well. And of course, the Basanti judgment, my lord, was delivered by Justice Venkatramaya as he then was. But we don't have
Basanti
the
actually for a moment.
Mada, that is the 31.
Mada judgment.
Let's see Basanti because it deals with,
So, my lord, it is actually easily distinguishable, but we can see it, my lord.
let's, because I think Basanti, because otherwise they will cite it, we might as well look at it.
Yes,
They
ma'am,
can
please
show us the relevant part they're relying on.
Please do. But I noticed that we don't have the historical problem that we have with Justice Chandrachud here with my lady, my lord.
Where are these judgments? Which volume is that?
Basanti Bai is in which volume?
But
Just tell us. Actually,
Volume
this
5.
one Dulya said, just give us all the three because you
Yeah,
have given us
very
earlier.
yes, I'll give you lordship all three. But just-
Singh ji is in which volume and which page? Volume 5?
It's all in volume 5. But give me just one moment. I'll tell you, lordship, what pages.
Any of the juniors on your side also have the pages readily, can just tell us. Bhim Singh ji is 2-4?
27. Basanti Bai, please.
Basanti Bai is at 2427.
Basanti is
2427. Lord,
192.
2294 is Sanjeev Kok. And 2192 is Bhim Singh ji. Yes, my lord, 2427. But let me just show you. Just help me, where is it here? Or just give me a moment, please, my lord, just a minute. Relevant parts. Relevant part. Lord. Yes. Basanti Bai.
Which is a relevant paragraph?
Yes, ma'am. So would your lordship just like to see the challenge in Basanti Bai first?
Sure. That is
Why
at
it
page
is-
2429.
2429, Lord. Lord, this appeal by special leave, Lord, it was against the acquisition of certain lands in Lonavla under different provisions of MADA. Lord, yes, chapter 5. This appeal by special leave is filed against the judgment dated 8 November 1983 in writ petition, by which the High Court declared subsection 3 and section 4 of section 44 of MADA to be void and gave certain ancillary directions. Lord, the facts are then stated, and then the question your lordship will find in paragraph 5. Lord, in paragraph 5 is at page 2432. May I? But in the course of this appeal, the parties have not questioned the correctness of the decision of the High Court as regards the facts which had been found against the respondent. The arguments were confined to the constitutional validity of subsection 3 and 4 of section 44 of the Act. Then, if your lordship would kindly go straight away to the discussion on 31C at page 2441, paragraph 13.
Para 13244.
2441. But even granting for the purpose of the argument that subsections 3 and 4 of section 44 are violative of article 14 of the Constitution, we are of the view that the said provisions receive the protection of article 31C. We shall proceed to test the validity of the argument, keeping aside for the time being the observation in Sanjeev Kok. Let us proceed on the basis of Kesavananda Bharati and Minerva Mills. Article 31C reads thus. Lord, clause B of article 39, which is relevant for our purpose. So, they proceed on the basis that it was very much alive and well, as your lordship says. States that the state shall in particular direct its policy towards securing that the ownership and control of material resources of the community are so distributed as best to subserve common good. The High Court rightly observed at the end of paragraph 14 of the judgment following Sanjeev Ko that the expression material resources of the community should not cover so and so. But, however, it erred thereafter in reaching the conclusion that Article 31C was not applicable to the case for the reason that the Act did not contain a declaration that it was enacted to give effect to Article 39B Roman 2 by undertaking development of commercial centers while providing housing accommodation. The authority was expected to make profits, and hence it followed that the power to acquire was not conferred with a view to achieving the directive principles of Article 39B. That was an important criteria in the decision-making of the High Court. And two, the object of enacting the legislation was obviously to provide wholesome civic life to the citizens and not distribution of material resources. We are of the view that each of these reasons is invalid and erroneous. First, Article 31C does not say that in an act there should be a declaration by the appropriate legislature to the effect that it is being enacted to achieve the object contained in Article 39B. In order to ascertain whether it is protected by Article 31C, the court has to satisfy itself about the character of the legislation by studying all parts of it. The question whether an act is in, sorry. Yes, exactly. Exactly. That is the point which is made. It's an entirely different point from the point which presents itself before your lordships today. And it accepts axiomatically 31C to be alive.
They follow Sanjeev Kok and Ranganath Reddy. They
Perfectly.
follow Justice Krishnayer's dictum in Ranganath Reddy and say that it has now been adopted by a constitution bench in Sanjeev Kok.
Perfectly put. Lord, that is the significance of this judgment. Lord, I have actually dealt with these three judgments.
Sent by Sanjeev. They cited the minority in Ranganath Reddy and say it was followed in Sanjeev Kok and therefore they are now.
Yes, but Sanjeev Kok itself is a remarkable judgment, Lord, where more or less the minority reasoning is preferred over the majority.
So now,
So, Lord, that's it.
the last part
Last
now.
part is all that is relevant. Lord, I only want to point out I've dealt with these follow-up judgments at page. Lord, the But there's, if your lordships will permit me, one beautiful line in Sanjeev Ko, where Minerva Mills is described as a
Rhetorical beauty is there.
rare beauty
Rare beauty.
and persuasive rhetoric. I have dealt with these follow-up judgments in page 105 of my note. Just for your lordship's convenience, it's there. But can I take your lordship now, my lord, straight away? All this was to clear the path to say that I can argue this point. My lord, it is, this point remains. Now your lordship will assess the strength of this point, my lord. My lord, it is dealt with by my note, which I had given to your lordship earlier. Lord, it is-
105, right?
Note 3, yes.
Oh, note 3, not in this today's.
No, but it's in the earlier compilation notes. Lord. Yes, not volume 1B, I'm told. Lord, whether Article 31C is a dead letter and whether unamended Article 31C should revive. Now, Lord, I'll just explain the note to your lordship in a second. There are two parts to the note. Lord, the first is what is the effect of the declaration of unconstitutionality upon the statute. Or that is the first part of the note. The second part of the note is dealing with this peculiar type of legislative activity, namely substitution and what it involves. So now these are two parts of the note.
One B.
Yes. I'll just wait for all of your lordships to pick up that note.
Is complete. So something.
So,
Having
is
of
that
that note,
page 38?
38.
But my learned friend, Mr. Devrajan, draws to my attention that I hope your lordships.
We don't
Come.
have, I think, anything
Oh, I see.
beyond 37.
37, the note ends at, no, I have 38.
I'll see.
There is 38.
Well, just
It is there.
sorry.
Whether Article 31C is a dead letter.
Yes, whether it's a dead letter and whether unamended or stood revived. Now, Lord, if I take your lordships directly to paragraph 3, Lord, all of which is exactly what I've been arguing, or the judgment in Minerva Mills declared section 4 to be beyond the amending power of Parliament.
You are saying that once section 4 is declared unconstitutional, that can't be revived.
So, Lord, I'm saying two things. The effect of unconstitutionality by your lordships is not to excise it from the statute book. It still remains a part of the statute book. It requires legislative intervention to then actually delete it. And this is exactly what they tried to do in the 44th Amendment Act, if your lordships recall. Lord, the part which was struck down by Keshavananda Bharati, they actually moved to say delete it. But for whatever reason, that motion didn't pass the Rajya Sabha. So, Lord, parliamentary practice.
45th.
45th, sorry, 45th. 45th Amendment Bill. Lord, it's a curious thing, but it's the 44th Amendment Act. So, Lord, it seems that there was one bill which didn't become an act. But I myself puzzled over that. 44th Amendment Bill was moved. That part which was allowed resulted in the 44th Amendment Act. So, Lord, one bill around the way, Lord, has got lost, missing, didn't pass.
That part
Yes.
not passed.
Yeah. No, my lord, your lordship has observed that problem, my lord. I have myself noticed that. I tried to understand it. So, my lord, this first part, my lord, the argument is in two parts. My lord, once Minerva declared section 4 to be unconstitutional, what was its effect on the statute book first? That's the first part of the argument. So, if my lady would kindly look at 3 onwards, or 4 onwards. It is submitted that the declaration by this honorable court did not and could not receive the unamended Article 31C. Sorry, could not revive, it should say. So, I'm so sorry, I misspoke. Could not revive the unamended Article 31C as stated and submitted below. Now, this is the reasoning about that declaration of unconstitutionality. When Section 4 of the Constitution was declared void, it cannot be said to mean that it was totally ineffectual and did not at all have the effect of amending Article 31C as contemplated in the 42nd Amendment. The substituted words continued to remain as a part of the Constitution. And here, my lord, I've illustrated. But see Article 368, my lord, I've quoted, thereupon the date of assent, the Constitution shall stand amended in accordance with the terms of the bill. So once the bill is passed, my lord, it effectively comes onto the statute book, and in the case of a substitution, in the place of the previous provision. There is a clear distinction on the effect of the statute when it is amended or repealed by a legislation and when it is struck down by a court for constitutional violation. So the two are different. Repeal is entirely different from striking down by a lordship's court. The effect of a legislation on the statute is a physical change. An express repeal, removing the statute out from the statute book. Parliament repeals, it's gone, it's deleted. An amendment makes physical changes in the statute, but a judicial decision does not make any physical changes in the statute. So I should say changes in the statute. It only places a particular meaning on it and leaves the statute on the statute book without any change. This difference is due to a clear separation of the functions between the legislature and the judiciary under our constitutional scheme. Note 7. No statute can go out of existence unless the legislature repeals it. The courts do not possess the power to make a statute or to repeal a statute. When a court declares a statute as unconstitutional, it is void. It is legally unenforceable, but factually, its existence cannot be wiped out by judicial declaration. In State of Bombay and FN Balsara, the Honorable Supreme Court had struck down Section 13 of the Bombay Prohibition Act 1949. This case dealt with a pre-constitution act. It was existing law on the date of the constitution. The question of the effect of its unconstitutionality, as so declared, came up first before a 3-judge bench in Pesikaka's case, Behram Khurshid Pesikaka versus State of Bombay. Justice Bhagwati, N.H. Bhagwati, held that the effect of the declaration of unconstitutionality, there was a slightly different view here, was not to enact a statutory provision or to alter or amend Section 13B of the Act. So, one thing I hasten to act. Now, my lord, we are speaking about its effect on ordinary statutes. One of the problems that we have had here, my lord, there is very little material on this point. And that has been noticed also in the NJSC judgment, which, my lord, I will be making some submissions to your lordship on. With regard to its effect on the constitution, my lord, is very little tried and decided, as I will show your lordship. But there is one or two, my lord, in my respectful submissions, persuasive indications.
After the provision is struck down,
Yes, ma'am. Sorry, ma'am.
whether they are bound to carry out the amendment also, deletion, addition, whatever.
Well, your lordship has raised a very good point. My lord, they may allow it to linger on in the statute book, as has actually happened and commented on by Justice Chandrachud, my lord, as he then was. My lord, to say it lives an italicized existence. So, my lord, when your lordship finds in the statute books, my lord, many of the parts of the statute in italics, your lordship will find a footnote there to say that actually it was struck down by this. Parliament has not taken the necessary step for
Whether
actually.
the Parliament is bound to do it.
Parliament is not bound to do it. Parliament may do it, Parliament may not do it.
For a layman, it is very difficult to understand.
It
The
is.
kind of argument being raised here,
Yes, ma'am.
that the earlier has revived.
My lord.
So nobody knows what was there, not there. So
Your
how a
lordship-
layman will understand this section?
No, your lordship is perfectly correct. My lord, I would submit to your lordship that for the orderly development of the law, Parliament must do one of two things. It must either remove it from the statute book, or it must remove the basis of its unconstitutionality and revalidate it by a parliamentary motion. That would be the correct parliamentary procedure, my. But I don't want to be misunderstood as raising a very technical point. But my lord, as I see it, this is an important point on the separation of powers between parliament and between
Statutes. And also provision struck down.
many statutes. And my lord, I would venture to suggest that in majority of them, parliament has not taken the necessary sweeping up action. Sometimes, my lord, in the 9th schedule, what was happening was that once it was struck down, it was immediately inserted into the 9th schedule to revalidate it.
Yes. But
So,
some-
but there also, Parliament is fully conscious of the fact that it requires parliamentary action for revalidation.
is there, but
It is always done. Because striking it down leaves it hanging, but what do we do with it? But may I just return, my lord, to the note, my lord?
Because very rarely there would be a question that the striking down was bad in law in a future, at a future date.
Quite right, quite right.
They don't do anything about it. They accept it unless they abrogate that judgment by removing the
31C.
Yes, your lordship is right. It's still there.
You can put it in an article somewhere. Effectively, it's nothing.
So, my lord, this requires a little, because the courts and parliament always work in tandem. At least the Supreme Court and parliament is to work in tandem. What the Supreme Court does, well, it may be accepted by parliament. Then you do away with it. You may not accept it, change the basis of it and revalidate it. But, my lord, parliamentary inactivity, in my respectful submission, results in the situation that we are in today. And it is difficult to see who can do it but parliament. So, my Lord Justice, Chief Justice put it to me, is this a technical point? Parliament can easily revalidate it. Of course it may. But, my Lord, Parliament in 2024 may take an entirely different view with regard to the insertion of an article which was done in 1972. It may delete it. It may revalidate it. It may bring it back in some other form. But these are all matters for Parliament to now decide. The baton, as it were, is handed over to Parliament to do what it will. And not the unsatisfactory consequence of this, that yes, we are left without the article, Lord, is a logical sequitur if we accept the fact that this is something which is left for Parliament to do. My Lord, I absolutely see the fact.
What is the logical sequitur of what you're arguing if the declaration of unconstitutionality does not efface the provision from the Constitution? It remains a part of the Constitution, but it becomes unenforceable. It becomes void and unenforceable.
Unenforceable.
Now,
That takes me to step 2.
What is the step 2 then?
So step 2 is that in the case of a substituted provision, what is remaining on the statute book is the unenforceable provision. That is actually, I'm glad your lordship asked, that is surely the logical consequence of
Say
this.
that again, in the case?
But in the case of a substituted provision which is declared unconstitutional, the same remains on the statute book, but is ineffective and is in fact void. And my lord, if your lordship were to push me a little further, my lord, I would have to say that there is no room for 2 provisions, one of which has replaced the other.
What they are arguing is the effect is that.
Is that exactly? Or what my learned friend.
So really speaking, what you're saying is this, that when Parliament substitutes in its constituent power a constitutional provision, then the effect of that is that the original provision
Extinguished.
is completely extinguished. That does not remain on the statute book because it's Parliament's power.
Well,
But when the substituted provision is declared to be unconstitutional by a court,
my lord,
that substituted provision still remains on the statute.
very
book,
much so.
albeit it is unenforceable. So the declaration of the substituted provision as unconstitutional by the court will not revive the earlier provision because the court does not enact a law.
Lordship has put it perfectly, but if I were to slow your lordship's
We'll
process,
hear the other side on this.
but if I were to slow your lordship's process down by just one step, what I would say that the declaration of unconstitutionality, Lord, brings to an end your lordship's examination of that constitutional provision. Your lordships cannot even say it stands removed from the statute book. It is now handed over to Parliament, who must take the necessary action on it.
And if it doesn't?
But we have the situation which we have today.
No,
It's a dead
but
letter.
will there not be something like an implied revival, something like that?
No, but,
But see, as your argument is actually very attractive.
my lord,
Philosophically, theoretically, it's very attractive.
my lord. No, my lord, I understand the pragmatic problem. But I understand the pragmatic problem that I'm faced with, and I understand the fact that it's viewed as a technical argument.
Access between the two. There you have.
That point remains, but whatever else is there, that point remains. But let me try during the course of the argument to address that point once again. I have a separate section, but where I'm going to try to address that point once again as well. Yes. Please.
Propose what fell from my lordships, my lords. Today, by a process of interpretation, they want your lordships to do something which Parliament said it won't do. That may kindly be considered, my lords. Parliament said it does not want 39B and C in its old form. That's why the 44th Amendment Act did not bring it in. Though the bill contained it, the act did not come. So today, by process of interpretation, they want your lordships to bring in something which Parliament said it won't do, my lord. My lords may kindly consider this subject.
I am very obliged to my learned friend, actually. My learned friend,
Not an NJC case for that.
we are going to the NGSC case.
You're relying on that.
Yes, but I'm going to show your lordship the NGSC case.
Just read the Article 31C now, what sense it makes.
It makes no sense. Your lordship is perfectly correct, if I may say so.
If the deletion is deleted, whatever is struck down is ignored.
It is
there
actually completely emasculated.
no sense here.
The only way it can make sense is if the old revives.
Yeah.
That is the only way it can make
When
sense.
if you pick up the book,
Yes,
then there is only part 4.
there's only part.
39 BC, as it was earlier.
Your lordship is right.
But then we'll have to read it.
But you, and yeah, and you know, your argument has a fiction implicit in it.
Well,
That, you see, normally when Parliament say substitutes an original provision,
well,
that substituted provision ceases to be on the statute. Right? Forget this particular case. When Parliament substitutes a provision in its constituent power,
yes.
the original provision ceases to exist. It ceases to be on the statute book. When the court declares or strikes down the substituted provision, it continues to remain on the statute book, albeit it
In
is
effect.
rendered unenforceable, null and void.
Well,
So therefore, according to you, and that is following the doctrine of separation of powers, that it is only Parliament which can efface a provision from the statute book. The court can only strike it down as unconstitutional. So when the court strikes down a provision as unconstitutional, that does not lead to the revival of a substituted provision which is exclusively within the domain of Parliament.
and there, my lord, your lordship once again has put it perfectly. But I would just add one or two perhaps logical extensions to that.
That's your argument, really.
That is my argument. But my learned friend, Mr. Devrajan, raised an excellent point, my lord. Parliament may express its parliamentary intent at that stage. It may say that I accept the advice given by the courts. I accept the fact that in fact it should go and it is unconstitutional.
For the court to revive a provision, according to you, is for the court to exercise a constituent power.
My lord. My lord. This in a nutshell is exactly what I've been saying.
You were not here yesterday, Mr. Devedi was making this point,
I heard it.
that it's just one exercise. It's not that the 39 BC will not come, because it becomes void ab initio.
Yes.
And if it is void ab initio, the 39 BC will automatically come, as if it was there in the statute book.
Yes, my lord. I heard my learned friend, my lord, and my lord,
Just because.
I have got some way of dealing with that, my lord. If your lordships permit, I'll just come to that at the conclusion of this. My lord, I want to deal with that in a separate way, my lord. About the effect of that unconstitutionality and the fact that it relates back to the date of origin of that particular constitutional provision. But I have some thinking on that also, because I heard, my lord,
It goes back to the original.
it is well settled that when your lordships declares it's void,
Declaration of
it relates back.
unconstitutionality relates back.
Relates
to,
back.
The date of the 42nd Amendment.
So, yes, my lord, I accept that, but there are just two academic possibilities. My lord, one is that it relates back to 1972. That's a possibility. Well, that's all I'm saying, because what has happened is that it's a 72 provision amended from time to time, because another problem is take the 44th Amendment Act. 44th, why should it not relate back to the 44th Amendment Act then? Why only the 42nd Amendment Act?
Well, now the amendment of the 42nd Amendment, was it retrospective or it was prospective?
Prospective. I think it has always been understood thus, but that's Vaman Rao. That's exactly what Vaman Rao says.
Probably this void has been noticed by a foresight in Vaman Rao, and they fall back on Keshwananda Bharati.
To say it exactly.
Say that the unamended provision was upheld in Keshwananda Bharati, and therefore they say that it is still alive and kicking.
Well, but I have had a similar thought about Vaman Rao because but I wonder sometimes what was the contribution of Koilo because Vaman Rao came so close to saying that 14 and 19 is basic structure. It just didn't say it in a sentence. And that was in 1980. So, but the contribution of Koilo of 9 judges in 2017, seven, what was adding just that one few more words to nail it to the mark.
Even if 14 and 19 are part of the basic structure, as we will have to now proceed on the basis of their being a part of the basic structure, that does not still dilute the rationale of Keshwan and Bharti, which is that it's not really a widespread or total, destruction of the basic structure.
It's a balance.
It's a balance, and therefore it is valid.
It's a balance. And Koilo is still relevant. What I had mentioned it to your lordship on that what Koilo should not be read as an absolute proposition to say that the minute you come against 14, it is something which will be struck down. What 14 is a nuance. At 14, 21 are nuance. We must apply the essence of that to the question. So it's just an oblique infraction. May or may not result in the statute being struck down. But to the pith and the substance of 14,
So really your argument which they will have to meet is in two steps. First, that when Parliament adopted the 42nd Constitutional Amendment, the effect of the 42nd Constitutional Amendment was that original Article 31C ceased to be on the statute book. Two, when the amended provisions of Article 31C were struck down by the court in Minerva Mills, the provision does not get effaced from the statute book. It remains on the statute book, but it is unenforceable.
It has lingered on as a dead letter.
Third, the declaration of unconstitutionality by the court will not lead to a revival of original Article 31C for two reasons. Bracket 1, the court, by the declaration of the substitution of the provision by Parliament in the 42nd Amendment, had effaced the provision from the statute book. And two, the court being treated to have revived
seek your lordship's indulgence to begin my story with Article 39 and not with 31C.
With Article?
With Article 39.
Yes.
As far as 31C is concerned, while a lot of things have been stated, both ideas, facts, concepts, which need a little more discovery, exploration, and response, if you may state like that. I thought better to engage the court first on 39 and then come to 31C later. There's a good deal of literature available. You'll have to permit me to make some broad preliminary statements, which are like a commentary on our constitutional history. A good deal of literary statements on the first 2 decades of our constitution, when the state was grappling with the issue of harmonizing fundamental rights and its obligations directed from state policy. Professor Tripaঠি's book on fundamental rights was a textbook it used to be in the early part of our curriculum. When all those eras were about understanding the dynamics of Part 4 of the Constitution, and when they get interlocked with citizens' claim on fundamental rights. You go back in point of time to how certain provisions of the Constitution came to be enacted and became part of the Constitution, particularly Part 4. We have so many explanations, theories, and so on and so forth, particularly in the context of Article 39 and few other provisions of Part 4. And those who want to draw one particular picture will say, well, this is a Marxist idea or a socialist idea, Irish constitution or a Japanese constitution, so on and so forth. But what is most important for us, I thought, is when constitutions are enacted, there are certain constitutional ideas which part of what called the understanding of the times. So there's a nice German word for it. Suppose what called the Weltanschauung, or what they call it. The feel of the times. So if you have that, therefore, when Part 4 came to be enacted, we had all the history of post-French Revolution, liberty, equality, fraternity, and then the Marxist traditions, then the Fabian socialism, utopian socialism, so on and so forth. So that's why Oscar Wilde said beautifully about a map of the world which does not have an utopianism is not a world to land at all. The soul of man without socialism and all that kind of stuff. So we have an idea of landing somewhere. But how do we land somewhere? Therefore, nobody could have probably said Part 4 is a perfect kind of a blueprint where we can land what this nation wanted to land. Nor one could have said Part 4 is a complete antithesis of either Part 3 and Part 4. But then that's how it began. Our constitutional history began with Part 3 becoming a complete antithesis to Part 4. It's in that context when the state has to grapple with solutions, ideas, and responses. So we have all these very important developments in the Constitution. So while we certainly at the 31st at later point of time, so we needed to probably erect a wall of support within the Constitution, while probably it could have been raised too high or raised too low is a different question. That's why we talk about basic structure. So there has to be a wall of support for many of the endeavors under Part 4 of the Constitution. So we see 31A, B, C only from that point of view. I'll address it a little later. Therefore, we look at 39B. Well, the Attorney General in minimum will say 38 is the bedrock of Part 4, etc., which is not probably accepted. But in a way, how do you draw up a roadmap for a better world? So if Part 3, if I can put it like this, is a provision for a saner and open society, but Part 4 is a roadmap for a better world. So if a roadmap for a better world, then every step which the state can take in a roadmap for a better world will always get interlocked with this an open society having everybody claiming certain rights, interests, etc. Therefore, unless we have that understanding, so we are not, Chief Justice said, we are not looking at Constitution as a mere statute. To look a dictionary on the one hand and read constitutional provision on the other hand and try to give meanings, etc. It don't happen like that. So when you use transformative constitution, it's also for the court, for the citizen, and also for the state. So it takes therefore a combination of all these three players in the society to idealize and to go forward in this mission. So I thought it's important for us. It may be taking cold to Newcastle, but I thought we'll break this little preamble statements in order to understand 39B. If your lordship can pick up my note, it is 2F. And well, the Constitution will certainly be
Correct?
And when Justice Holmes said in that Lochner versus 2F, your lordships.
Four horsemen. Four horsemen versus three musketeers.
Two F or two F?
2F.
First paragraph is Article 39.
Revise,
Revive. Why?
submitted twice.
Oh, no.
Yes, sir.
The first sentence is Article 39, right?
Yes. Yes, it's not so rapid.
Yeah, Article 39 of the Constitution. That's right.
Fusion, yeah.
As we are talking about saying the Constitution is not treated like a why?
This 5 pages, yeah.
8 pages.
Lordship, it may be called 2F revised. We don't.
That also has 4 pages.
Eight page, right?
7 pages.
This one 2F, right?
Two F amendment.
7 pages.
2F.
Where is that? Not there?
With this, it's 8.
Huh? I hope your lordship has that.
We have 4 pages now.
It's about 78 pages. Including the cover page is 8 pages.
Your original 5 pages, do they remain on the statute book? Are they pages?
Maybe they will not remain on the statute book.
Are they unenforceable? Are they substituted, effaced from the statute?
Maybe
book?
I will have the liberty to keep on revising them from time to time.
Yes, Article 39.
That is like to be or not to be the question.
One is the legislative exercise,
Yes,
one is the court exercise,
yes.
and now we are confronted with the Attorney General exercise.
Which your lordship can say the forensic exercise.
Yes.
I just saying, he talked about constitution expressions are not to be treated like common statutes. I thought one more statement. Well, certainly court in the context of a transformative constitution says, I'll have meanings to Article 21. But I want to say that while adding or giving meanings to certain expressions of words of the constitution is different from adding concepts and categories which may essentially fall in social, economic, or political realm. Giving meanings is one thing. Right to life includes livelihood. A telegraph includes telephone. But when you talk of concepts and categories which fall in social, economic, and political realm, court will be very ordinarily reluctant to treat them as meanings to be added into the constitution. I'll make good this submission little later. So when you talk about what is a resource, what's a material resource, what's a common good, etc., we will definitely have to pick up several social, economic, and political concepts and categories and thoughts. The common good is not something which you can go to a dictionary and find a meaning. Like when the UN declaration on new economic policy came, there was a lot of sociological literature on what is common good versus public good. Therefore, we have to probably travel into those areas where social, economic, and political concepts and ideas have a certain free-mingling way. So I was trying to find out whether the court will be a little slow in bringing those ideas into this or taking them out of 39B or the directive from state policy, as the case may be, like when we do in the context of ordinary statutes. Now let me read this. Article 39 of the Constitution of India, and in particular, 39 clauses B and C are best understood as a combination of social, economic, and political principles. The organization of human life involves the organization of our activities, transactions, and our interactions with the physical world for the purpose of sustenance and welfare. All of the above can happen with the world of resources available both in natural state and made available by human interaction. So all things in the material world which are available and made available by human interaction or engagement constitute the resource of the community. That's a very broad statement, I think relevant for the purpose of understanding 39B and also 39C. Then how do we understand the following? Resources. Anything or object in the material physical world that human beings can use, exploit for human consumption or use, as also anything or object that can be made or created for any human purposes, will all constitute resources of the community. It's because that both resources available in nature and resources made by human interaction are of utility, value, and relevant for human purposes that Article 39B has in mind ownership and control. That's the reason. Material.
So therefore,
Fulfillment
private property, in your definition, there is no concept of a private ownership at all.
It talks about all resources. That's why Ranganath Reddy said man-made plus natural. He did not go into a private ownership. He talked about only this distinction. Natural versus man-made.
But it has to be a material resource of the community.
Yes, yes. I'll try to address that question. Because after all, we live in a material world. All resources which we use and create are all material resources.
But they may not be material resources of the community.
I'll come.
Your formulation.
I'll just come.
Anything which is created by the application of private labor is a material resource of the community.
They are material resources, but they're community resources is a different issue altogether.
No, because you have said.
I just come to that. Allow me to.
Because you have said that, you have said of the community, that's all things in the material world.
We are not trying to address it. What are a material resource?
And made available by human interaction or engagement constitute the resources of the community.
That's right. I'll try to make good that as I go further. So material fulfillment of
a house using my own income, that's
Yeah.
a material resource of the community.
no.
Or if I own a car, that's a material resource of the community.
What I create, I make for myself, for my own personal consumption.
What I
It doesn't
earn
go.
by
It doesn't
salary.
transcend. It doesn't transcend beyond a certain limit or a boundary.
What I earn by way of a salary, by the.
That's true. It can. That's in a given case. Therefore, what I create, if it doesn't go beyond a certain boundary, it may remain my private resource only for my human consumption. But the moment it goes beyond the boundary, then it becomes there is an element of the community having a call on that resource. Community will have a call on that resource.
Only the taxes which will.
That's
be-
why transportation service. Transportation service.
But,
I want to, so that for the little broad, we can come back to it. I want put that broad canvas so that we understand where we probably land.
will we be
Yes.
sort of treading the right path by divorcing your definition that you are giving from the word community? After all, community has a connotation. And you are saying that whatever the human resources is capable of generating can also fall into the ambit of community. That becomes a little difficult. The government can tax, certainly suppose somebody is earning an X amount, so much tax. Y amount, so much tax. But then it becomes resources of the community.
As I develop it further, I think a little more clear. What I'm trying to say is, we don't live, as the poet, English poet John, we don't live in isolation. All of us live in transactions, interrelationships. So the wealth we create, the value we create, are all by our interactions in economic activities. So the word resource in 39B essentially connotes an economic base. It has to be understood from that framework. So if we are talking about wealth, value created by human interactions, and as long as it remains, for instance, I dig, yes.
That means a corporation which produces cars, or a corporation which produces semiconductor chips, corporation which produces mobile. All these are resources of the
They
community.
are all resources of the community.
Material resources of the community.
They are all resources of the community, in the most fundamental constitutional sense. The next question is whether, to what extent state can enter into regulating, etc., is a different question altogether. That's where we land probably into scanning of the state's control, state's regulation, prohibition, restriction, to what extent, degree, all that questions will come later. But if we look at resources as a very narrow area, that's why I thought the referral order talks about private versus public resources. Perhaps that's not what Ranganath Reddy was talking about. When it said man-made resources, it all meant resources which are in private hands. Capital, share values, they're all resources.
That probably capacity to raise loan was also mentioned. And if somebody can raise a loan also, that is also the material resource.
Yeah, I want to lay a foundation that I know there'll be all questions about why do we have a very broad canvas about a resource. I understand that, but I thought let me place that and then try to find out where we are able to navigate further. may read it and then come back to this resources concept once again. So we're looking at material. Fulfillment of human sustenance needs and other connected purposes happen through human interaction with the material world. Non-material resources of the community are not contemplated in Article 39B. For example, culture or literature or non-material resources. This distinction is sufficient to understand the use of the word material. So that's why where I create something for myself, a piece of poetry or literature, a culture, where a way of living. So it doesn't enter into a state's domain to own and control. But anything else besides that are the material resources of the community. So in the early days of the socialist thought under the Fabian utopian socialist thought, etc., they looked at land, factories. You go back in point of time, 18th and 19th century, the textile mills in England, or what Maxim Gorky talked about in his book Mother. So it's all about that narrow resources which were in that at that point of time. But they still included both private and public resources. But as we moved into an further what's called enhanced understanding of the economic role that a state need to play in the ownership and control of all resources, I think today, regardless of the fact that we have moved away from a very given up notion of the socialist controlled model, regardless of all that, the need and a necessity for the state at any point of time to take stock of the resources of the community for subserving the common good will always be an open question. So therefore, it's important for us to understand why, along with the moving times, if we give certain or contemporary meanings to these expressions, then we would have served the constitutional purpose of ensuring that 39B and C play their role well. The moment we try to cap and confine Article 39B, saying that concerned only with land or mineral resources, etc., then we are probably missing the most important message under Article 39B, as it must evolve with the times. So therefore, the only way I thought one could look at it is the distinction between material and non-material. What is non-material is certainly not within the ownership and control. And what is non-material, we can have many examples like this. So as I said, it is not exactly a dictionary definition. We have looked at the social and economic history of how all these ideas evolved over a period of time. So we must land there and then to probably able to have an understanding of why Constitution captured it, probably with certain base or inspirations at a given point of time. But as I say, we must also infuse in this meaning which will keep the Constitution alive. So let me take to the next part of it, common good and distribution. The words common and community must be read together. Community connotes a set of people adhering to an organized way of life in a given locality, and it would also include a section or part of it. Again, you go back to sociology, community has so many connotations, urban community, rural community, or a community with reference to a particular faith. We're not talking about that. So community can be a nation, community can be a part of a nation, community. Therefore, the geographical area where people have an organized way of life is a community in the large sociological understanding of this term. And the word community, even before the 1900s, been used in several senses, but the most important sense, like the sociologist Max Weber was talking about, it is a set of people living in an organized locality and sharing certain values, would like to interact and live as part of a clan of people, a group of people. Therefore, the word community will have to be given that kind of an understanding. So at a time when economic scarcity was to be dealt with, control of trade and commerce in several essential commodities were all for the common good of the entire community. At a time when economic scarcity was to be dealt with, control of trade and commerce in several essential commodities were all for the common good of the entire community. Cement was a controlled industry, like gold used to be earlier. In the context of this case, the housing needs of a particular section of the people is the common good of that section. The housing needs of a particular section is the common good of that section. Distribution can mean spreading, which suggests equal allocation of resources in favor of the defined class of persons on the entitlement of common good. If we then see why ownership and control will come in, understanding of ownership under the legal thought is well known. It includes matters such as title, matters such as absolute discretion of the use of property or a resource. Control includes elements of regulation and can extend up to prohibition. The meaning of the word restriction in Article 19(2), as expounded by the court, suggests the latitude of choices available within the scope of restriction or control. So that is probably the larger view of looking at 39B and C. If you have that in mind, then as I proceed a little further, if you look at paragraph 4, the object of Article 39B is the realization of common good by recourse to the resources of the community. To the extent such resources are under the ownership or control of citizens, the state is called upon to explore the common good and for that purpose deal with the ownership and control of resources in the hands of citizens. Once resources are in the hands of the state, no further questions about ownership and control issues will make sense. The reference to private resources in the order of reference, Honorable Court, may properly be read as a reference to human-made resources. That's what Ranganatha Reddy has in mind. So Article 39 is in the company of directive principles of state policy. It has enacted principles of social, economic, and political equality and the realization of an egalitarian social order. In Kasturilal, this court, Honorable Court has held, I read, it was pointed out by this court in Ramanadayaram Shetty that with the growth of welfare state, new forms of property in the shape of government largesse are developing, since the government is increasingly assuming the role of regulator and dispenser of social services and provider of a large number of benefits, including jobs, contract, licenses, quotas, mineral rights, etc. There is increasing expansion of the magnitude and range of governmental functions as we move closer to the welfare state, and the result is that more and more of our wealth consists of these new forms of property. Some of these forms of wealth may be in the nature of legal right, but the large majority of them are the nature of privileges. Therefore, today we're talking of a very expanded understanding of new forms of property. Banking, insurance, the whole technology in several services, they're all new forms of property. And most of them are in the service of the community. So you snap good part of a technology and economy today, I think the whole organization of social life will collapse. So much of our economic activity depends on how do we harness human interaction, producing economic wealth and for the common good. While certainly the regulation and control, how we do it is a different question. So also the concept of public interest must be, as far as possible, receive its orientation from the directive principle. But according to the founding fathers constitutes the plainest requirement of public interest set out as the directive principle, and they embody par excellence the constitutional concept of public interest. If therefore any governmental action is calculated to implement or give effect to a directive principle, it would ordinarily, subject to any other overriding consideration, be informed with public interest. That's one shade of common good. Then directive principles of state policy and fundamental rights are the two wheels of the same chariot. Please see so and so. I will skip these two paragraphs for the time being. I will come to para 8. As I come back to Minerva Mills, I'll read paras 56, etc. Then paragraph 8 in Lochner versus New York, Holmes with his dissenting note had observed as follows. For a constitution is not intended to embody a particular economic theory, whether of paternalism and the organic relation of the citizen to the state or of laissez-faire. It's made for people of fundamentally differing views, and the accident of finding certain opinions natural and familiar or novel, and even shocking ought not to conclude our judgment upon the question whether statutes embodying them conflict with the Constitution of the United States. That's why we're talking about the Constitution being read in more than one sense and in an enlarged sense wherever the demands require. Now, paragraph 9. Having regard to the constitutional context in which Article 39B is located and its relevance towards realization of an egalitarian social order, any narrow or truncated reading of the provision may itself be offensive to the free play that is desirable in the working of the principle enshrined in Article 39. There is nothing in Article 39 which suggests of any limitation or qualification of the words used therein. The distinction between public or private resources or natural versus human-made resources is alien to the spirit of Article 39B and C. That's why I said we will not read into the Article 39 any economic, political, other categories or concepts which are not themselves found in Article 39B and C. Article 13B and C could not probably otherwise word it. They tried to convey a whole range of aspirations and principles of building an egalitarian social order. So it's not like drawing a statute. 39B and C is not like drawing a statute for a working purpose. So therefore, I started saying that unless we have in mind the whole historical background which led to the formulation of these ideas and principles, they have to be treated as signposts. And the signpost may not be said, I'll cross a line here on signpost. Then you will never understand the signpost. So a cursory glance of cases decided by the Honorable Court with reference to Article 39B provides us an insight on the range of resources which have come up for consideration. For instance, in Banerjee versus Anita Pan, it's a case of freezing on suit for eviction by transferee landlord for 3 years. Then the next, I skipped Ranganatha Reddy, serial number 2, and 3, Bhim Singh Ji is about land, Sanjeev 4 is about coke oven plant, which is then a processed mineral. Then serial number 5, Abu Kawar deals with a whole range of issues, but particularly stage carriage and contract carriage, which is on par with Ranganatha Reddy. Abu Kawar deals with a whole range of issues, but particularly stage carriage and contract carriage, which is on par with Ranganatha Reddy. Then 6, National Textile Corporation, assets of 6 textile undertakings, mills and industries. And they are obviously private properties and private resources. In Union of India West Cyanamide, it's a case of regulating drugs, pharmaceutical industry. In item 8, serial number 8, it's a case of regulating electricity as an industry. A constitution bench. Then Pathasarathi, serial number 9, where a company is issuing shares, Capital Control Authority were to regulate the share market. So shares as resource of the community. Then Orient Paper Industries. So you have a forest, you give a license to cut bamboos and then make them as a forest industry. And then 11, a refractory plant, again an industry, which is a true industry in the economic sense. Then item 12, we look at grant of dealerships of petroleum products. So it's a public resource, equality, to bring about equality in accessing public resources. So look at a wide range of resources which have to necessarily come within the ambit of distribution for common good. Then 13, land, 14 is about mines and minerals, 15 is again about a mining lease. So the whole law of mines have undergone a sea change now. And you still say auction or otherwise to allocate material resources to the community. Then Mafatlal, was a case of refund of excise duty, where they pressed into service 39D. I'll show all those judgments. Then 17 is natural gas. 18 is again a question of grant of natural resource. Then Coal India, recent judgment where Nagaratna was there. Then application of the Competition Act to nationalize coal companies. So how competition element is important even among public sector undertaking. 39, was brought into picture and it was discussed there. So I just gave a few illustrations to show that how the resources of the community will have to be understood from a very large framework of what will serve both individual, sectional, or collective good of the community. So sometimes it can be an individual need in the disabled part of a community who may require a certain technology improvement to serve them. So there has to be financial incentives. Which company will do that? I mean, regulate it. Therefore, the regulation and ownership and control will subserve not only that, when they talk of common good, it's not necessarily the entire national good. It can be the good of a certain section, an identified section of the community. And that's a state obligation. Where is this? The other submission? I'll tell you what. Turn to volume 2. No, should not read this. I'm sorry.
Who is it?
Volume.
Volume 2. Which one you want me to do? Yes, I read it. What we have done here, yeah, the shorter one was like a paraphrased one. This is a detailed one. I also appear for MADA. Therefore, it is done keeping that in mind.
Yes.
Yes. What I've done here is each paragraph, I'm sorry,
Page 38.
page 38. I'll quickly, each paragraph refers to some judgment or the other to catch the, scale the wide meaning of resources which our courts have dealt with earlier already. For instance, in para 13 at page para 12, the idea of distribution of material resources of the community as prescribed under Article 39B is not necessarily limited to the idea of what is taken over for the distribution among the intended beneficiaries. I'll read each one of them a little later, just giving a broad overview. In para 13, the theme of the amended provision of the MHID Act advances the social cause of the homeless families, and the provisions contained therein can easily be classified as a socially beneficial statute. The courts on various occasions have expressed the reservation in striking down a socially beneficial statute dead unless a plain breach of the fundamental rights citizen is manifest. That's what Anita Pan says. That's just Anita Pan just before in Ranganatha Reddy. It just preceded Ranganatha Reddy. Para 14, courts have to ensure the directive principles are not to be dismissed with a master teasing illusion and a promise of unreality, curtailment in public interest of such extreme rights of the landlord as are read in tooth and claw is a constitutional compulsion. Then I'll skip Ranganath Reddy for the time being to come back to it later. Let's just turn to page 40, para 19. That's a statement from Bhim Singh. There's a wide misconception that only the public utilities can subserve the common good and fulfill the objective of common good. It shall not be an understatement to aver that even a private resource may be for a national need and serve the common good. Article 39B of the Constitution should be construed in the light of Article 38 and understood as placing an affirmative obligation upon the state to ensure the distribution of material resources does not result in heightening inequalities among people and among regions. Then Article 39B envisages state shall in particular direct policy towards securing ownership and control are so distributed that resources observe the common good. Socio-economic justice, read the arc of the Constitution. Public resources distributed to achieve that objective, since liberty and meaningful right of life or age with availability of opportunities and resources to augment economic empowerment. We just look at it like that, and how are opportunities created in the social world? It's not merely an opportunity for an employment in the public sector. So opportunities created by economic transaction, economic activities. So unless you have enough opportunities and equal opportunities, even outside the realm of the state, and that's where the ownership and control made itself, so the common good principle comes in. So mandate of Article 39B does not impose a restriction on the means adopted to subserve the public good and uses the word distribution, suggesting that the methodology of distribution is not fixed. So when natural resources are made available by the state to private persons for commercial exploitation exclusively for their individual gains, the state's endeavor must be towards maximization of revenue. This alone would ensure fundamental rights in Article 14 and directive principles in Article 39B are extended to the citizen of the country. Then, in Jijubai, each word in Article 39 has a strategic role, and the whole article has a social mission. as a strategic role.
Yes.
That page. Yes, yes. Each word in Article 39 has a strategic role, and the whole of article has a social mission. It embraces the entire material resources of the community. Its task is to distribute the resources. Its goal is to undertake distribution as best serves the common good. It recognizes by such distribution the ownership and control of so-and-so. Term resource is a sweeping expression and covers not only cash resources, but even ability to borrow credit resources. Each one's judgments add on to a certain, facet to the understanding of resources. The word distribution used in Article 39B must be broadly construed so that a court may give full and comprehensive effect to the statutory intent contained in 39B. It should not be construed in a purely literal sense.
Mr. Attorney, come straight to para 27 of your written submissions. That's what.
27, Your Lordship.
That's exactly what you want to convey. Where you have referred to Jijubai.
Yes.
Just come to that.
I'll read that.
And then you can conclude.
The material resource of the community is a wide concept, broadly interpreted to bring within sweep all resources, natural or physical, movable or immovable, corporeal or incorporeal, tangible or intangible properties, etc. Private resources or property are part of the material resource of the community. All things that produce wealth for the community. Why is it stated to be so widely, sweepingly made? Oh, as I'm trying to understand today, I think every little part of our life on an organized basis takes place by reason of a wide range of economic activities coming together. So when you say all that produce wealth, when you talk of wealth, for instance, in the early part of the 18th and 19th century, we talked about the wealth which is available as part of a land or a wealth you have produced and put it in a bank. Wealth today has no such, minimal connotation. So that's why we talk about different forms of property. Today we talk about emerging forms of property. So wealth must be understood in that sense, not merely monetary wealth.
Legal rights, correct?
I'm sorry.
Wealth would be in the nature of legal rights. But the large majority of them are in the nature of privileges. We are just putting it to you.
No. Let me complete reading this because I thought while this was a very engaging issue in the sense that you don't have a very pedestrian answer to it. You can't say, well, private resources are exempted from 39B, but then we don't answer the question, what are those private resources? How do they come about? Therefore, in Jijubai, they look at the larger way of understanding. Yes.
Go into these issues at this point of time.
We can. I'm trying to, why that we need to go into it is to say that 31C has lost its relevance in the sense that we are an open society, a free economy. We're not talking about a very outmoded Marxist notion of distribution of wealth. I don't think the court should look at it in that perspective. In the economic history of a country, we still have large mass of population who need to be brought succor to their life. So it's from that point of view, 39 was enacted, and we still have not traveled a good part of the journey. Therefore, to say that it has now lost its Marxist connotation, I think would be to look at only Marxism and leave everything else outside of understanding. If that is the way, probably then China would not have probably taken this course of regulated capitalism. So therefore, it's important for us to say that we will not halt or the arrest the progress of certain part of our constitution and leaving it in the responsible hands of the state to regulate the ownership and control of resources, to subserve the common good. Each one of them in a given context or a statutory context will be certainly scrutinized. There will be certainly a judicial review of whether does it serve a particular common good or a public good, or it's an illusory, common good talking about.
That's the core issue.
That's right. That certainly will happen. That tool is available in the hands of the court. But to say that, no, we will try to give a very narrow meaning to 39B and to curtail its broadest expansive understanding and the potential of its use in the hands of the state.
Yes.
In Jujubai, in that paragraph, they talk about providing access to equal opportunity. That's why, for instance, we have in the New Deal era in the 1930s, the Lawson era they call it. So provision of economic opportunities for the racially segregated. So the US Supreme Court should deal with them. So equal opportunity in the economic field. So accessing banking resources. So a wide range of resources today are evolving. So access to those who must act, for those people who are not able to access them on their own. So when Amartya Sen talked about the capabilities approach, he looked at a world where it can be probably brought by certain amount of state involvement in it. So unless I have the capabilities built with me, which can happen only if I have access to resources. So if I don't have access to a human housing resource, so what did Olga Tallis talk about? So if so you take away my life and therefore you take away my means of life, I take away my life. Shylock talking about in Merchant of Venice. So access to many things in life today depend upon how they can be made available by voluntary economic engagements and by state engagement. So the facilitating, the enabling environment can be built only when you have a certain understanding. But that does not mean the state can lay it very broadly, can lay it arbitrarily. That's a different area altogether.
Social and economic justice.
Yes.
Which is there in the preamble of the Constitution.
Your Lordship, please.
Justice includes social and economic justice apart from political justice. So it is in order to ensure that goal of the Constitution, we have this Article 39.
That's why you're entirely right. Therefore, we are talking of the amalgam, the interconnection between social, economic, and political dimension of a society. So for long, we had this dialogue in human rights, the civil and political rights. We'll have a precedence over social and economic rights. But then there is no longer a debate in human rights. We are part of one common human rights, endeavor. Therefore, the interconnection between this. See, if 39B was to die a natural death, once Marxism was dead, it's a different answer altogether. I don't think we probably wish to give that answer. Maybe there are even contestants on whether Marxism is dead or not. I was thankful Chief Justice yesterday about Gandhiji's censorship issue. When there was a large amount of criticism about when Gandhiji made this, very interesting proposition. And there was a lot of potential about it. Whole set of Marxists criticized Gandhiji for saying that he's serving a bourgeois interest, to borrow a Marxist expression. So, but that's probably, we'll move towards a whole amalgam of Gandhiji's censorship ideas, access to resources ideas, and how do we build them? Do we have a kind of a blueprint for all that? That's why every experiment in the economic field, every experiment in the social field for all experiment to move towards, as it's called, the movement towards a better world.
The salutary nature of Article 39 as such.
Yes.
The debate is when it is applied and the application which it has under Article 31C.
Yes.
I think you should go to the next chapter. Nobody is doubting the salutary aspect of Article 39.
No, when you are right, but if you are talking about a private resource immune from 39B, that's how the argument has been built. These are our private property. Good part of it constitutes of livelihood or whatever it is. And therefore, they're immune from Article 39B. There can't be any law which seeks to invoke Article 39B as a resting house. Therefore, it's important for us to understand this broader, canvas of 39B. Then one can find out whether the law is good or bad is a different issue. Because from 1940 onwards, the rent has been frozen. And therefore, we really do not have the potential, enjoyment of the property. That we are in the particular context of a law. Whether that law is bad because of it closed eyes to a certain history, that is a different question altogether. But we are here trying to understand and settle the meaning of what 39B would actually take within its broad sweep. If it is read very narrowly, well, yes. If not, yes, then the implications need not necessarily be a matter for the court to think and say, if a law is made wrongly on an abusive understanding of 39B, I don't think today, given the kind of limitations on lawmaking power and the competition in the political field, egregious wrongs will happen. They may happen on the fringes, but not necessarily in the core of social governance. I don't think it's likely to happen. But of course, there are blunders which governments can make. Blunders for certain short-term political, whatever. We're not talking about that. We're talking about how do we read a constitutional provision. If one was to say that 39B has lost its vitality, we can say yes. Or if you had to say, no, provision like 39B can never lose its vitality. No, yes. So it can never lose its vitality because it has a kernel of importance for social organization and moving towards a better world. That's the kernel of 39B.
We can come to para 37.
37.
Article 31C.
Yes. 30.
31C.
No, this 37 goes into a 31C argument. I propose to come to it a little later. As I have said, request the Chief Justice that since very incisive arguments have been advanced on 31C, and also with the contribution from all the Chief Justice, adding well to the understanding of this case, 31C. We need a little more time to reflect on that. It's not that we write one 31C like this and say we give goodbye to 31C. So it's
4 o'clock today as the conclusion.
I would like to look into it little more carefully to make any argument. Though all of us have some thoughts on 31C, but I don't think that should be thinking on the feet and then responding to it. It needs a certain reflection and a responsible reflection.
Clock today, Mr. Attorney, so
Huh?
we have to wrap up by 4 o'clock. So maybe The arguments will conclude at 4 o'clock, so please leave some time.
No, it's very difficult. You know, this, Your Lordship, this is an important matter where two salient provisions of the Constitution are being debated. And 2.5 days on the other side, I could, of course, write a précis writing and hand it over to the court. But that's not what the probably court wants from the attorney and the solicitor general. And we need a good deal of investment of our time and mind to assist the court in every possible way.
Complicated. And it can't be finished, my lord. I'll just on a lighter note, my lord, there can be 2020, 1 day or 5 day. My lord, the fielding team should get as much time as the other team, my lord, got. My lord, we are fielding team.
All right, yeah, Mr. Attorney, can we just suggest one thing, that if you can wrap up by say 3:30 today, then we can start with the other.
My lord, I would need, my lord, about one session, my lord.
We'll see that, but if attorney completes by 3:30, we've got now the general drift of what the learned attorney has to say.
I will try to do that, but that's like pushing me to the wall.
So right now, till now, you are showing us the land,
Your Lordship, please. Sir.
showing us the land.
I only try to take off now. I know where to land.
Now you have to land.
I know that. I know, but I've not read, for instance, every one of us, by reading the same part of a judgment, has a certain way of reading it, a certain emphasis, looking at a particular word or expression and draw sense out of that. So I've not read quite a few judgments, which I would like to read them. But I'd like to say a broad outline. I thought that would be the best way of going about it to begin with. Because I was also trying to look at, I'll do that. Also, which one? The attention of the Chief Justice also on this very, very engaging subject of the more you draw it wide, what happens, the more you close it wide, what happens. And of course, it's one has to reflect on it. I looked at 39B very closely after this matter occurred. You look at every part of it. Either you treat 39B as having served a purpose for a period of time and fold it up and wind it up and keep it like in some constitutional mausoleum and keep it there. Or we say, no, it still has to have its vitality. Therefore, one looks at various expressions used in it. So like the common good use. So the common good, as we're trying to point out, as I said, an individual can also have a common good. A set of people who live, a tribal people, set of people, they have their common good. So protection of the minerals, as Samata said, is a common good. The tribal has the material resources to be so distributed for their common good. Of course, ownership and control.
I think you have brought in the concept of distributive justice. That is at page 50, para 54. I think that is what ultimately you are trying to sort of canvas.
Paragraph, Your Lordship, sir.
54, just the heading of that, concept of distributive justice. I think when you talk about serve the common good, I think this is what you are trying to perhaps.
That's right. That's
concept of distributive
justice. Your Lordship, sir. For distribution.
These are your words, but I think this is what your argument is, I think, geared towards.
This paragraph is an extract from Linga Papochana. And I would say there's one part of it. Distributive justice, again, has often been seen as a liberal thought or a quasi-Marxist thought. I'm not looking at it from this very doctrinary economic understanding. So a distribution of a resource of a community today may have very imaginative understanding of that. So distributive justice in that sense, but how do you actually apply distributive justice today? How do you handle them today? So if you need a bedrock for that, let 39B remain as it is, with that larger connotation which we're trying to suggest to 39B. So that is para 54, distributive justice. Let me just quickly read it since your lords are that. It's at page
52, part of 52.
page
Just
52 bottom.
quickly glance to it already.
I'm sorry. The concept of distributive justice in the sphere of lawmaking connotes inter alia the removal of economic inequalities and rectifying the injustice resulting from dealings and transactions between unequals in society. Law should be used as an instrument of distributive justice to achieve a fair division of wealth among the members of a society based upon the principle. I'm not talking about robbing Paul to give Peter. That's what the usual old dialogue against Marxism. I'm not talking about that. From each according to his capacity, each according to his, but again a Marxist credo. But the distributive justice in the constitutional sense means something else. Here, claims of equality will be taken into account. The right to a private initiative, creativity, innovation, which is Article 19(1)(g) is about. So liberty is all about creativity and innovation. 19(1) is about it. So the state will have to maneuver amongst all these conflicting areas of, again, emerging fundamental rights. So if you're only at chapter 3, we have no difficulty at all. We only clash among fundamental rights. So we can probably as well say chapter 4 has done its day, then pick up few provisions of chapter 4, and the rest of it can be given an exit day. That's not what can happen in a dialogue like this. The distributive justice comprehends more than achieving lessening of inequalities by differential taxation, giving debt relief and distribution of property owned by onto many who have none by imposing ceilings and holding both agriculture and urban or by direct regulation of a contractual transaction by forbidding certain transactions.
Distributive justice. Now we go to concept of socio-economic justice, para 60. The arc of the Constitution. Then rules of interpretation. Courts cannot adopt it, doctrine may adopt it. We can go now to para 62, UN report on public goods for economic development.
Paragraph 60 is only either summation of what is this socio-economic justice. In the previous paragraphs from 56 onwards, it's a little bit of a history about, you go back to Aristotle about what's a common good. So he talks about in Aristotelian understanding, then later medieval understanding, then Enlightenment understanding, later the socialist and other understanding. The common good has always received a wide range, but then ultimately it's about how do we organize our lives to requiring that our human interactions and economic transactions benefit not only a few, but everyone. So in a pre-industrial society, the things were different. In a post-industrial society, it's going to be very different. In a machine age, it's going to be very, very different. Therefore, the importance of looking at it from a very, what called potential, a provision which has got a potential utility, and that can be invoked as flexibly as possible.
Tell me, what is this UN report on public goods for economic development? Page 56.
Page 62.
Para 62.
I'll just compare it. Not have paragraph 62?
Yeah.
A common good or resource is one that can be exploited for private gain, but that no one owns. Free access to these goods bring up a basic management problem since the criteria derived from private benefits do not coincide with those that public or intergenerational interest demand. Private benefits call for the most intense exploitation, while public or intergenerational interest demand the establishment of control mechanisms to preserve the resource. Thus, the characteristics of both non-rivalry and non-excludability can vary across classes of public goods. There are instances when an activity may simultaneously yield two or more outputs called a joint products, some of them public or with different degrees of publicness. The degree of publicness varies according to the dimension and characteristics of the public effects. These joint products, such as education and biodiversity, benefit both those who receive them and the entire society by fostering more responsible social behavior. The idea of the public effects.
Now we'll see the common agenda report of the Secretary General.
Yes, I'll just do that. The twin concepts of the global commons and global public goods are used in various contexts and fields, including law and economics. The global commons usually refer to natural or cultural resources that are shared by and benefit of all. They include the four conventionally understood commons that are beyond national jurisdiction: the high seas, the atmosphere, Antarctica, and outer space, all of which are now in crisis. Public goods are understood as those goods and services provided to and benefiting all of society, which at the national level may include street lighting, fire department, traffic control, or clean water. Certain public goods have long been acknowledged as being global in nature, in that they cannot be adequately provided by any one state acting alone, and they concern the welfare of humanity as a whole. These have traditionally ranged from global aspirations of peace, practicalities, civil aviation regulation, etc. Ultimately, what distinguishes these precise domains is that their protection is in increasing the task that can only undertake together. Then provisions of so and so, I'll just skip that. Then there's a need to look at some of these statements in Sanjeev Kok and Ranganath Reddy in the sense that why they look at the resources very broad canvas.
The chapter 8A of the MADA Act, I think in the context of Article 14 argument is dealt with.
It is there.
Yes.
Yes,
right.
yes.
I think that would be something of relevance.
But that's where I just want to hint at that, because the court is not called upon to decide the legality of that act here.
Classification.
Yeah, the geographical classification held as permissible classification, hence making provisions applicable only to the island city of Bombay cannot be held to be arbitrary and reasonable. Such classification, therefore, cannot be held to be impermissible, nexus with the objects of classification. Stopping here for a minute, as I said, any section of a community in any defined geographical area or a class of people with a defined aspiration, understanding, needs, demands, requirements. So therefore, the public good concept, the common good concept, all that will have to be woven into it in a way that they ultimately seem to serve the purpose of sharing the resources. That is not. Come to the first part of it here. Early part.
'74, salient features of chapter
Which one?
page 63.
Para 74, that is with regard to the act, page 63.
These paragraphs takes us in the details of the legislation and how it's not arbitrary, etc. So I suppose once the court sets the base for understanding of 39B, then any court who scrutinizes this act will look into that
What
aspect.
you're saying is that.
I put them all there. I don't think I trouble the court with that.
39
I'll
in a
trouble,
very broad-
yeah,
in a
that's right.
broad
That's
perspective.
right.
Broad perspective.
That's right. So why did Ranganatha Reddy go into this question and Sanjeev Kokinkol thought Ranganatha Reddy was a clear case where a transport service, nationalization of transport service is now part of our national economy and every state has done that. Now they coexist today, they're private and public transport services. And whether they do well or not is again a different question. You may have all kinds of accusations against the poor quality of a public service. The same can also be extended to private services. I think there's nothing different about it.
Thank you, Mr. Attorney. With your usual characteristic precision, you're finished 10 minutes before your allocated times.
I would like to read Ranganatha Reddy because it's an Anita fan, Ranganatha Reddy, and I'd like to come to Mafatlal to quickly say that it is not an arbiter. It's not an arbiter at all. There's 9 judges sitting together looking at Sanjeev Kokinkol, what had happened earlier, and they say, look, and then the counsel raised an argument before the court. Look at these aspects of this case.
Mafatlal, I will cover, other two you can cover.
Yes, Mafatlal, you are.
Mafatlal, I'm talking about Mafatlal. Sorry.
Mafatlal, there is just one paragraph, para 86.
83, 84, 85, 86 of Mafatlal.
Cover other points. Cover other two.
So kindly give me Ranganatha Reddy.
First, Anita Pan.
Anita Pan.
Anita Pan is involved.
Now again, read Ranganatha Reddy. If you can just tell us the point that you're making, we'll make a note of it.
Can you read Anita Pan was volume 5D, page 154.
With the paragraph.
5, 6, and 32.
This is volume 5D, page 156 or 154? 156.
And 32. And this statement was my question earlier.
At page 160, PDF 162.
Volume 5D.
This was a case of a Rent Control Act.
This is volume 5D.
paragraph 6, page 162,
Volume 5D.
volume 5D. Some background observation to appreciate the contest in court are necessary. No social realist will deny the frightful dimensions of the problem of the homeless families and precarious tenancies, and if the directive principle, state policy are not to be dismissed by the mass of the teasing illusion and a promise of a reality.
Volume 5D.
Volume 5D.
President, President.
Have that page?
Starts with some background.
Yes.
That's right. Some background observation to appreciate the contest, and no social realist will deny the frightful dimensions of the problem of homeless families and precarious tenancies, and if the directive principles, their policy are not to be dismissed with the mass of so-and-so, curtailment in public interest of such extreme rights of the landlord as a ready in tooth and claw is a constitutional compulsion. The court, informed by this sore economic situation and reinforced by initial presumption of constitutionality, hesitates to strike a socially beneficial statute dead, leading to escalation of the mischief to suppress with the human high house legislated, unless, of course, a plain breach of fundamental right of the citizen is manifest. Which is the paragraph. Then paragraph 8. The explosive import of neglecting such a distressing urban development reasonably obliges the state to impose drastic restrictions on landlord's right to property. And when circumvention of wholesome legal innovation is practiced, on a large scale, the new challenge is met by clothing the law with more effective armor, and that is the rationale of the Amendment Act. The learned judge rightly referred to the legislative proceeding, notorious common knowledge, so and so to be brought to the can. The soundproof theory, ignoring voices from parliamentary debates, once sanctified by British tradition, has been replaced by the more legally realistic and socially responsible canon of listening to the legislative authors when the artifact is being interpreted. We agree with the High Court when it observes. Then kindly turn to paragraph 12 at page 165. This is an example of how the court may look at it, not by holding lenses with a narrow approach, but the law, so and so, etc. We emphasize this fact of sociological jurisprudence because the High Court struck down with on surmises, possibilities, and maybe rather than on the study of actualities and proof of the nature, number, and age of pending litigation got in the respect of so and so. Judges act not by hunch, but on a hard fact properly brought, sufficiently strong to rebuff the initial presumption of constitutionality of legislation. As the court of the chamber or the House to weigh whether it should legislate prospectively or draft the clause differently. We find no foundation of the large assumption, so on, so, etc. Yes. This over, this is over.
Volume 5, page 17.
One. Page. Not getting it.
Mr. Chetan, we'll have a look at the judgment. Ranganath Reddy. Then give us a small note maybe later on.
37.
This is the one where they don't agree with.
At page 1749,
Five.
volume 5. Where is it?
This is the one where they disagree with Krishna.
Four plus 3 in Ranganath Reddy is to be seen as 4 plus 3, not 4 minus 3. In the sense, as Untwala is saying, we've not taken to concur with Justice Krishnaya. Here is what they say in paragraph 37. End of paragraph 37. Our learned brother Krishnaya has prepared a separate judgment specifically dealing with this point. What's the point about? The transfer of certain funds which have been taken from the secured creditors, and whether 31C will cover that issue. Therefore, the judges say that is being dealt with separately. And then Krishnaya judgment himself at page 1750.
That is why Justice Untwala.
We go only with our learned brother Untwala.
That's why he said that we must not be understood to agree with all that he has said in that judgment in there. Normally, you give a dissenting judgment, and that remains.
That's right. But the judges understood as far as 31C is concerned, there's another opinion. I understand it, everybody having agreed on that.
No.
In the common theme of the judgment. I'm talking about the common theme of the judgment.
No. In fact, my lord, what Justice Krishna Iyer understood to be a concurring opinion, Justice Utwalia say is in fact a dissenting opinion. In a different way. Very clear that we should not be understood that we have agreed to that. Agreed with all, yes.
All that he has said. Now, I'm trying to look at it like this. The court is called upon to answer a question whether nationalization of a transport service would fall under 39B. See, that was the main question. So the act was upheld. The act is upheld, which means it doesn't fall foul of any constitutional provision. Whether on the expanded logic of 39B, natural resources meaning or not, the act has been upheld. That's what I'm trying to say. Therefore, if 39B expand, a meaning has to be given to support the outcome of the judgment. Krishna has endeavored to do that. So if you have to look at 39 at all, you have to look at it. One seven. One. So, kindly just pick up only a few paragraphs, Lords. Kindly at page paragraph 79, at page 1770. Majority view and so and so settled by the court and stated. Lords, to skip a few lines and a little later. Article 31C has also been upheld, subject to the rider that there should be no nexus between Article 39B and C
Should be.
and the object of the acquisition. That's right. There should be. Our learner so and so has struck a middle note and pointed out that where the inputs of valuation prescribed by statute are only irrelevant or unconnected with the social good, then Article 31(2) may not retrieve the statute. It's a far cry from this observation to the position that the 25th Constitution Amendment leaves untouched the ratio in Cooper. You pointed out how the said constitutional amendment was expressly undertaken inter alia to undo the effect of Cooper and to forbid forensic diagnostics into the question of compensation. In this light, it's difficult to uphold the view of the High Court that Cooper survives after death and keeps virtually alive the obligation of payment of market value inclusive of usurious rate of interest and all that. Then next, kindly turn over to paragraph 81. Resources is a sweeping expression and covers not only cash resources, but even ability to borrow. Its meaning given in Black's dictionary. And keeping that dictionary meaning, and material resources of the community in the context of reordering the national economy, embraces all the national wealth, not merely natural resources, all the private and public source of meeting material needs, not merely public possessions. Everything of value or use in the material world is a material resource, and the individual being a member of the community is a resource as part of the community. To exclude ownership of private resource from the coils of Article 39B is to cipherize its very purpose of redistribution the socialist way. A directive to the state with deliberate design to dismantle feudal and capitalist citadels or property must be interpreted in that spirit, and hostility to such a purpose alone can be hospitable to the meaning which excludes private means the production of goods produced from the instruments of production. AKSN agrees that the private means of production are included in the material resources of the community, but by some baffling logic excludes things produced. If a car factory is a material resource, why not cars manufacture? Material may cover everything worldly, and resources according to so and so takes in the collective wealth of a country or its means of producing wealth, money or any property that can be converted into money assets. No further argument is needed to conclude that Article 39B is ample enough to rope in buses. The motor vehicles are part of the material resource of the operators. Which is the next paragraph. Then paragraph 83. 83, page 1772. Two conclusions strike us as quintessential. Part 4, especially Article so and so, is a futuristic mandate to the state with a message of transformation of the economic and social order. Firstly, such change calls for collaborative effort from all legal institutions, systems, the legislature, judiciary, and the administrative machinery. Secondly, and consequentially, loyalty to the high purpose of the Constitution, that is social and economic justice in the context of material want and utter inequalities on a massive scale, compels the court to ascribe expansive meaning to the pregnant words used with a hopeful foresight, not to circumscribe their connotation into contradiction in the objective inspiring the provision. To be parasitic towards the Constitution through ritualistic construction is to weaken the social, spiritual trust of the founding father dynamic faith. When Krishna talks about the social, spiritual trust, probably he also has in mind Gandhiji's trust issue.
Please read paragraph 88.
What? I'll just come. That's a conclusion.
Yes, that is
That's-
very important.
There is another stark possibility. Now, before that, para 87 also, Lords may just make a note. Legalism has yielded to when spacious issues arise. Whatever the legal aspect of the thing, there are moments when it's feeble read to rely on and so in the Constituent Assembly. There's another stark possibility, the administration sliding back from the progressive constitutional values to the protective private interest. And the court may activate the welfare jurisprudence of the Constitution by appropriate commands. While I would go along with what the learned judge has said here, as I was trying to point out, we are not we're not asking the court to read Article 39B from a particular economic prism, not a particular economic lens. The moment we try to bring into Article 39B any particular economic doctrine, I think we are going to crib and confine it. It must have its openness. While it might come in at a point of time from a certain social, economic, or an ideological understanding, if it has remained part of the Constitution, it must receive that expansive meaning. But if it doesn't require that expansive meaning, because we say with the death of a particular ideology, we don't need this, to hang upon. Then it's a different story altogether. It's a political story.
So isn't this a caveat against privatization and liberalization, which is the order of the day today? And where private enterprise is being encouraged. And as a result, the increase in private wealth would ultimately lead to the increase in the nation's wealth.
Absolutely. I'm not saying,
world, that
I'm
is
not
the
saying in the
philosophy.
classic sense, the classic Marxist sense, you regulate everything, nationalize. I'm not saying that should be read in, that's the way it has, in fact, such constitutional provisions will receive wisdom and maturity in an evolving constitutional framework. So therefore, even we have a private expansive, private market or private capitalism, whatever one may have, but this provision will still have a certain relevance.
So His Lordship Justice Krishna seems to be warning against what is the scenario today.
He wrote at a point of time when, with his own understanding of what would be reading into Article 39B. But I don't think that's only one index. It's one index of looking at 39B. But I'm looking at various indexes which may have to brought into 39B. And we do not know how many indexes are going to be there. To say that I'll look only a Marxist or a socialist index, and they're all dead for all practical purposes. Why should we go into it at all? But that is again a political philosophy, understanding. But I suppose if the Constitution has to do a journey beyond what we are seeing today, therefore, we can probably wipe out many of the provisions in Chapter 4, because we are living in an open society of a free.
Look at it. Each word of the Constitution can have a different meaning at different points of time.
They can have.
That is what, so we cannot only think of what was there
Exactly.
in 1950s.
Exactly.
The same words can be interpreted in the 21st century.
Absolutely. Therefore, we are not, suppose we are talking about right to privacy, Article 21, a wide range of interests under Article 21. So I suppose all those values which go into an expansive constitutional interpretation are not to be confined only to certain provisions of the Constitution. They may have to probably inform the most important part of the Constitution, namely Part 4.
Certainly, we'll close now, I think, today.
Yeah.
And we'll start on Tuesday with the solicitor submission.
I have not touched upon 31C. We will have to probably, after solicitor, deal with 39B.
We'll see if something remains,
Yeah.
then we can
So
always.
31C, we still need to come back to.
Yeah, I'll combine both, my lord, and assist your lordships in a composite way thereafter, my lord.
Or if your lordship permit me, I'll try to deal with 31C as early as quickly as possible.
Heard the broad drift of your submission.
Yes, yes.
We'll start with now the solicitor on Tuesday, and then Mr. Dwivedi will be arguing thereafter. Solicitor said you take about one session, right?
One session, but maybe it's a few minutes here or there.
And then Mr. Gopal Shankar Narayan after Mr. Dwivedi. Try and
I have my
leave a little bit time for them for the rejoinders so that we can wrap up on Tuesday.
That may, my lord, we will not repeat anything.
Besides, you are always Mr. Solicitor. That's why we are taking this liberty with you and Mr. Dwivedi. Trust us that we will not.
Your lordships are never, my lord.
Never rush you, but if possible, you can leave a little time for the rejoinders so that Just the salient points they can state in the rejoinder, then they can supplement it with a note also, no difficulty.
Because if you Lords permit me, after Mr. Gopal Shankar and I need just 5 minutes, Your Lords, for a small intervention, just 5 minutes.
Mr. Shankar Narayan is appearing for
Also, the state of West Bengal.
State of West Bengal.
Just
And
5 minutes.
what about you?
Because I'm for an interview.
For an interview. We'll see how much time we have left.
Maximum 2 minutes.
So Tuesday is in the West Bengal matter.
In Mahada matter, my lord, he is appearing for the tenants, my lord, who will be opposing the
This for the petition.
Mr. Devraj.
We'll try and wrap up on Tuesday.